Ladies and gentlemen, good evening. We're going to call to order our first hearing of the evening. That's a 7:30 hearing. It's on the application of Thayer Nursery. Today is October 12, 2017, and this is the 7:30 application. I'm going to summarize the application. It's by Thayer Nursery. It's dated September 8, 2017, and they're seeking an amended special permit to the zoning bylaw in order to have their annual holiday boutique on the first Sunday in December from 10 to 4 in the afternoon at the Thayer Nursery property, which is located at 270 Hillside Street in Milton. The applicant was previously granted a limited exception special permit for the holiday boutique on December 4, 2016, and the nursery is located in both a Residence A and AA zoning district. My name is John Leonard. I'm chairman of the Board of Appeals. With me this evening, to my immediate left is board member Jeffrey Mullen, and to my immediate right is board member Ted Daber. The rules of the board are such that we'll first hear from the applicant. We'll hear from persons present who have questions of the applicant. We'll hear from anybody present who wants to speak in support of the application, or anyone present who either wishes to speak in opposition to the application or wants to modify the application to some extent. We're tape recording the premises this evening, so that would ask that before anyone speaks, tell us your name and address, speak up nice and clear and loud, so that we'll have an accurate record of the proceeding this evening. The microphones that are in front of you of a tape-recorded television version of this show, and they don't amplify your voice. So speak up nice and clear and loud. With respect to this application, we're going to have as evidence the application signed by Maggie Oldfield. It's dated September 8th, 2017. In addition to that, we have received some letters speaking in support of this application, which were filed today by about 12 different individuals. We've received no letters objecting to the substance of this application. We did receive a letter from Attorney Matthew Dunn. That letter is dated October 12, 2017, and I understand that Mr. Rowe wants to read this letter into the record, which we certainly will allow him to do so. I think without further ado, Ms. Oldfield, are you all set to make your presentation? Welcome back to the Board of Appeals. Why don't you tell us what your application is all about and why the board should extend the special or grant a new special permit, and with a little emphasis on why you want the special permit for a term of years rather than an annual special permit.
Sure. So for the past 13 years or so, the nursery has been holding a community event called the Holiday Boutique. It has been traditionally held on the first Sunday in December. And what it is, it's an event that brings the community together. I sympathize with all the local craftspeople who do not have a brick and mortar storefront. And so Christmas is a great time for everyone to come together and sell their crafts. So basically, in 2015 and 2016, the Board of Appeals granted a limited exception special permit, allowing us to have a holiday boutique at the nursery at 270 Hillside Street, and each special permit was for 1 year. This year, we are requesting the same limited exception special permit for a one-day holiday boutique, but we're requesting that the board grant the permit for a period of 5 years. In all other respects, the request this year is exactly the same as it was last year, and the same conditions and limitations would apply. The request is for a 5-year permit to hold the Holiday Boutique on the first Sunday of every December from 2017 through December of 2022. It would expire in 5 years from the date a special permit, if you were to grant it, would become effective. Therefore, in 2023, before the date when it would expire, we would be back in front of you requesting it again. Since the request is the exact same each year, it creates unnecessary cost to us and hence to the artisans who attend, and requires a hearing and a new permit every year. So a 5-year term is a reasonable term for such a permit. Furthermore, the board can alter, amend, or add conditions to the special permit at any time after notice in the hearing. And this language is part of the 2 previously granted special permits, and I would assume that it would be included in any new special permit. And it provides recourse if any problems should arise with the event during the next 5 years. So if you have any questions, I'm here to answer them.
Yes, I've got a statement. You sound like Mrs. McGettrick. Have you been attending law school of late?
No, I've just been watching you.
Okay,
every
thank
2
you.
weeks.
Well, that'd be a dangerous thing, as people will tell you. So let me just ask you this. In terms of the nature of the event, is it going to be approximately the same type of event as last year and with a similar number of artisans, and you're going to coordinate this event with the fire department and the police department and protect neighbors' properties from improper parking or other?
Correct, yep. So one of the things that the police department requests of us is that we post no parking signs on at least one side of the street, so it allows enough access for any fire engines to get down the street if needed.
Okay. Let me see if my colleagues have any questions. Mr. Mullen, do you have any questions of Ms. Oldfield?
Not right now.
Mr. Aber?
I just have one. Do I remember that you, from past years, that you do have somebody out there helping with the parking or directing people to park? Or
Yep, so we have our own staff, and usually it's about 6 of our employees, and they are placed throughout our parking area as well as at the entrance of the nursery on Forest Street. Usually the police detail is on the corner of Hillside and Forest.
Okay, so you do have a police detail as well?
Yes, yep.
Okay, and, okay.
Yep.
And that's in the corner of Forest and...
It's usually a Hillside and Forest, yep, yep. But it's wherever the policeman on duty feels that he's needed. But our guys all carry walkie-talkies, and so they speak to each other that way to see if there's parking to direct people into the back lot or to the side lot.
Okay, and the police detail is there the entire time?
Yes. Yep.
Okay, great. I have no other questions.
Okay, do you have anything else you'd like to add? Let me just put into the record so that it's clear, because a lot of people have written emails to the board in support of your application, and I just want to acknowledge them so they'll know when we receive them. I'm not going to read the substance of what they say. They all say wonderful things about your boutique, and that they want it to continue. Some of them want it to continue for the 5-year period. Others don't mention it. So what we've received is a communication from Joni and Kevin Morris of 7 Academy Lane, Milton, from Margie Flanagan of 145 Old Farm Road, Milton, from Mrs. Kenny at 82 Parkwood Drive, Milton, from Judith Sandonato of 116 Reservation Road in Milton, from Jeannie Schmidt. I don't have her residential address here, and I'm not going to read her email address into the record. From Joan Gankarski of 75 Oak Street in Milton. Judith Tanza, sent via email. And to Heidi Graff of 245 Atherton Street, Milton, Massachusetts. So we thank all of these citizens for participating in the hearing. Let me ask, is there anybody present who who has either questions of Ms. Oldfield or wants to speak in support of this application? Okay, the record indicates there's no such person present. Is there anybody who has any questions or wishes to speak either in opposition or to modify any of Ms. Oldfield's requests? Yes, Mr. Rowe. Do you want to come up and be heard?
Good evening. John Rowe, 23 Parkwood Drive.
Good. Welcome to the Board of Appeals, Mr.
Thank you. Our attorney, Matt Dunn, has written a letter on behalf of me and Phil Johanning, Director Butters, to Thayer Nursery. And I'd like to just read the letter into the record.
Good. Would appreciate that. Take your time.
Dear members of the Board of Appeals, this letter is submitted on behalf of Philip Johanning and John Rowe of 23 Parkwood Drive. It is our understanding that Thayer Nursery has submitted an application to you seeking a permit to host a holiday boutique at its property located at 270 Hillside Street every December for the next 5 years. While Mr. Johanning and Mr. Rowe do not oppose Thayer Nursery's right to apply for such a permit on a year-to-year basis, provided that it is in compliance with the town's zoning bylaws and the requirements of the special permit that the Planning Board issued to it on July 15, 2016. They do oppose Thayer's request that this board issue a 5-year permit now. As a preliminary matter, Mr. Johanning and Mr. Rowe would like to point out that the inaccuracy of the Thayer claim that 5-year permit would correspond with the duration of its special permit. Pursuant to paragraph number 11A of that special permit, its term runs only to July 15, 2019, 3 years. This time limitation was intentional. It was put into place by the Planning Board so that it could ensure that Thayer Nursery complied with all of the terms of the special permit. Thayer Nursery has proven repeatedly that such oversight is necessary based on its long and documented history of flouting the requirements of 1, the town's zoning bylaws, 2, the board's decisions, 3, the building commissioner's cease and desist letters, and 4, even orders of Norfolk Superior Court with respect to this property. Accordingly, Mr. Johanning and Mr. Rowe ask that this board take the same measured approach as the Planning Board in limiting the duration of the permit that allows Thayer Nursery to host a holiday boutique to once annually, and subject to Thayer Nursery's demonstration that is in full compliance with the town's zoning bylaws and the special permit. By its own conduct, Thayer Nursery has proven that such a carrot-and-stick approach is needed to ensure its compliance with these land use restrictions, and that such an outcome would not otherwise be possible if this board were to grant a 5-year permit. In addition, Mr. Johanning and Mr. Rowe asked that the board condition its issuance of any permit allowing Thayer Nursery to host its holiday boutique on the requirement that Thayer Nursery secure and pay for a police detail to, 1, control vehicular and pedestrian traffic, and 2, enforce parking restrictions in the area on the day of the event. Historically, this event has drawn hundreds of people, and such a requirement is necessary to ensure the safety and welfare of attendees and residents. I also want to point out that this board issued a special permit to hold the holiday boutique in 2015, and one of the requirements was that they have a police detail, and they did not have a police detail in 2015. They came back in 2016 asking for another permit, and this board issued it. And in 2016, they did have a police detail. So it's things like this where the first permit you issued, they didn't even comply with the conditions you put on the permit. I have no confidence that Thayer will comply on a year-by-year basis with what they're supposed to do if you issue a 5-year permit, simply because there's nobody to hold their feet to the fire. And this board, the number of times we have been in front of you simply because of noncompliance of multiple court orders, orders from the building commissioner, and your own orders, Thayer has proven that they simply will, I guess, do what they want to do. And I really think we need to hold their feet to the fire. And like I said, well, first of all, retail sales are not permitted in the residential zone A or AA in Milton. Retail sales were not permitted or contemplated in the bylaw amendment that allowed them to apply for a special permit to operate a landscape and firewood distribution business. They actually asked the planning board during those hearings to put the retail sales in the permit, and the planning board denied their request because it's not allowed in the bylaw amendment that allowed them to issue the special permit for the landscape and firewood business. This is a one-day event that affects me for approximately 3 weeks. 2 weeks of the racket where they built out the lathe house, hammering, construction, etc. The day of the event, the traffic, the vendors arrive long before 10 a.m. on Sunday morning to set up, and they're dismantling after 4 in the afternoon. We are not going to oppose a special permit that is issued for 1 year. But we do oppose, a 5-year permit. And I just want this board to understand this one-day affair that, I don't know, apparently benefits a lot of people. They sell a lot of Christmas trees that day. It is a big inconvenience for the neighborhood and especially the abutters. So I just ask you not to issue a 5-year permit.
Great, thank you, Mr. Rowe. Is there anybody else who'd like to be heard regarding this application? Mr. Johanning, please. I'm sorry, Jeff.
I was going to ask Mr. Rowe a question.
Mr. Rowe, can you come on back? Mr. Mullen has a question, please.
So this is the third time, at least, right? Maybe the fourth time we've gotten together like this?
It's at least the third.
Yeah.
Yes.
Just on this issue.
Yes. On
And I think it's the first time that we actually heard these kinds of detail. I'm interested. Did you go? I went 1 year. Did you go? Do you go?
No.
How is it?
In my backyard.
No, I know, but
look out the window.
we've never really heard, from somebody about how it is. I mean, I know you testify. What I got from your testimony and from Matt Dunn's letter is, it's fine if it's 1 year and they have a specifically required for a detail. And I'm assuming that the other conditions that are in the permit you'd support those as well, since it's pretty detailed what they can and cannot do. And the testimony from Thayer is they want the same permit that they got last year, except for a 5-year term. Is that accurate? Yeah. But what is your? You didn't really. I know you said it's an inconvenience and it starts earlier than 10, and it's a big deal. What's your sense of the event? Is it a good event? Is it a bad event? You don't have to answer if you don't.
I don't. No. It is, in my opinion, this is an event to get people to go to their nursery on the first Sunday in December to buy their Christmas trees.
Is it controlled?
It is not controlled. The traffic is bedlam. You can't drive through there. So that day, you know what I normally do on this day? And I haven't looked at the schedule, unless the Patriots are playing at 1 o'clock, I clear out. If the Patriots are on at 1, I'll stay home, close the windows and watch the game. But other than that, I clear out of town. Okay. So, I live in a home in a residential district, and this is just not allowed. I understand that people think it's fun to buy trinkets at Christmas and, go to Thayer Nursery and get their tree. Fine. We're not going to protest this, but the issue here is Thayer Nursery has proven for many, many years that they never comply with what they're asked to do. And you, this board knows that. How many times have we been before you?
More than once.
This board issued cease and desist orders in 2013 and 14 for retail sales. We've been in front of you and in front of Norfolk Superior Court. The list goes on and on. The building commissioner has been up there many, many times, issued several cease and desist letters over the years. Their behavior does not warrant anyone to issue a permit for more than 1 year. You have to hold their feet to the fire. If you issue it for more than 1 year, there's no opportunity for us to come back here and say, they totally misbehaved. It was chaotic, an unsafe situation. So this, I think, is the only way to handle this situation based on Thayer's past behavior. I didn't do it. They control their own destiny here.
Okay, thank you.
Mr. David, do you have any questions of Mr. Rowe?
Not at this time, no.
Okay, thank you.
Okay, and again, we're not opposing a 1-year permit.
Gotcha.
And if they want to do this, I think they need to come in front of this board every year.
Oh, you've made that perfectly clear. Thank you, Mr. Rowe. Mr. Joe Henning, did I see your hand? You wanted to be heard?
I do.
Good. Welcome back to the Board of Appeals.
Thank you, Mr. Milton. My name is Phil Johanning. I live at 23 Parkwood Drive. I only want to say a few things, and it sort of gets back to the compliance issue. The question about whether the event is nice or it's not nice is to me, is not relevant. It's what's in compliance with the zoning and what is not. People love to go to the South Shore Plaza, I'm sure. The parking lot is jammed at Christmas time, but it's not permitted in a Residence A or AA zone. So, people's affinity for shopping at holiday times is surely fun.
It's nostalgic.
But it's not permitted in my neighborhood. And the confusion and the uproar is not permitted. I don't see why I have to leave my home on the first Sunday in December. I don't understand that at all. I bought a house in Milton in a residential zone, and I have to leave my house. Do you have to leave yours ever? Because of confusion in your neighborhood?
No.
Well, sometimes if neighbors are having weddings or parties, and they set up their tents in the backyard and they rock and roll till 10:30 at night. But it happens to everybody. I understand what you're saying.
We're talking about something that's more frequent than that.
Well, this is an annual event.
Well, it's more than that.
Proposed to be an
It's
annual.
more than that. It's not completely silent there all the time for us. And another thing I'd like to point out is that among the letters you referenced, only one lives in the neighborhood, and none are direct abutters. So that sort of tells you how neighbors feel and how direct abutters feel. Not one is in favor. So we're not the only people affected. My neighbor, Chris Stevens, stopped by last Saturday and was talking to me, and he lives at 39 Parkwood Drive, and he was talking about the Holiday Boutique, and he said, he started laughing, and he said, "I'm sure I'll see you there." We're not the only people. We're the only people who show up, but we're not the only people who feel that they're inconvenienced by this. And when you get down to it, it's the direct abutters, the direct neighbors who really have to be listened to. And finally, I want to get back to the issue of compliance. The building commissioner issued an occupancy permit, and we didn't object because we sort of know how these things go. But the truth is that not every aspect, not every requirement of the special permit has been satisfied. One of the requirements that I talked to Joe Prondak about was lighting. They, under the special permit, are supposed to have some protection around the lights so that it doesn't spill over onto my property. Because every year, starting around late November and going through January, we have light, pouring into our yard. It's like the daytime out there. And I asked Joe, what about the shrouds or the protection from the light? And he said to me, well, they couldn't find them. They couldn't find something. That doesn't matter. The requirement of the special permit is that there should be some protection. Joe thinks it's okay that they couldn't find it. I said, ask them to take the lights down. They didn't take the lights down. So we're talking about specific requirements that the town allows to be justified that harm us, and no one cares. And that's how it goes. And so that's why it's very important to us that some protection be given to abutting neighbors to ensure that they either comply with the requirements of this one-day special permit, let's say, or they lose it. That just has to be until they show more of a desire. I know I said finally, but finally is that Thayer never approaches us as neighbors to talk about the Holiday Boutique and how it might affect us and how we could work out compromises. They don't inform us of when it will start, when it will end, when the construction will begin, when it will end, how will this affect us as neighbors. They never come and meet with us, the abutters, the neighbors, and I think that's that's not neighborly. I remember a long time ago, Mr. Leonard said, why can't you people work this out? I suppose we could if someone would approach us and let us know what's going on and give us the opportunity to have input. But that never happens, which is another reason why I think a one-year permit is really appropriate. Thank
Can
you.
I ask you two things? Number one, do you still have this arbitration process going back and forth between you?
Absolutely. And I'll say one thing about the arbitration. If it weren't for our civil suit, we would have no protection from the requirements of the special permit. The special permit would not be executed fully if it weren't for our civil suit. And that gives you an indication of the kind of protection we receive from the town of Milton. And so when we have to go and have an extensive pretrial 22 depositions, et cetera, et cetera, et cetera, in order to get protection that we're entitled to under the zoning bylaw amendment and under the terms of the special permit, that gives you an idea of what kind of protection we're receiving from the town, what kind of enforcement we're getting from the town. Thank you.
You've been here many times, and these events have been hashed back and forth, but you understand, and I just want to put it as part of the record, that the lighting, having shading and protection from having lights flow onto neighboring properties like yours is an important condition of the special permit, so that if you think that you're not securing an address of your grievances regarding important issues, you have the perfect right to send Mr. Prondak a letter, and if he doesn't act, file an appeal with this board, and we'll have a hearing on it and get it determined. And you understand that. I just wanted to mention that to you. I'm not suggesting you do it, but if you want to do it, that's a substantial condition of the special permit. It's not incidental, and it would be my hope, but I'm not going to lecture anybody here, that has been or will be cured within a short period of time if they couldn't find whatever protection they need.
Even regarding the civil suit and the requirements of the,
That's all right.
even regarding that, one of the things that could happen is that Thayer Nursery could come and talk to us about problems that they encounter. I don't want them to talk to me necessarily, but they know my attorney's email, they know my attorney's, and what I'm talking about is not the suit itself, but about an attitude. And what I'm saying is that if we're supposed to get together, find accommodation, things like that, one of the things that Thayer Nursery could do is reach out to our attorney and explain problems, issues, things that they want to do, and see if we could reach agreement in advance. That never happens. And so I just simply say, if we want to be neighborly, if we want to get along, I'm not the one that's asking for special permits or waivers of zoning bylaw. I'm not doing that. They are. So it's up to them to reach out to my attorney so that we can find a way. But that doesn't happen, and that's important. Thank you.
Thank you, Mr. Drainer. We appreciate. Just one second, Mrs. Oldfield, and I'll give you the floor. Is there anybody else who would like to be heard with respect to this particular application? Okay, there's no one else present. Mrs. Oldfield, do you want to speak very briefly as to Mr. Rowe?
More brief than some other people. But I just want to assure you that protecting our neighborhood is always our first priority. We own 8.5 acres and 4 houses. And because we live in the neighborhood and we're raising our children in the neighborhood, retaining safety and the special character of our neighborhood is always our primary concern. I've lived in the neighborhood for 48 years. My 82-year-old mother still lives in the neighborhood.
Oh, that's wonderful to hear. She's a wonderful person.
We want to reassure you that we will not be adding any additional noise for our events. In theory, any additional noise generated by this type of event would be minimal and would actually be shouts of fun and laughter from lots of children. The boutique is held during the day, during our regular business hours, with no additional use of equipment. Our request is extremely limited in scope and makes good use of our existing farm. It is a natural extension of our farm's mission to develop successful and personal experiences and creating lasting customer friendships while supporting a local legacy of agriculture and community. The boutique does not take away from our prominent use of the land, which is agriculture, and having community events that support many of the vendors who already participate at local farmers markets preserve this prominent use notion. This one-day event is a de minimis use that benefits the community. And we are only asking to amend our permit to include the holiday boutique. And each year we strive to improve our business and our overall customer experience.
Could I ask you one question? I remember it from last year's. Do a portion of the proceeds from this fair, are they donated to charitable endeavors?
Yes.
And could you tell me approximately how much money last year was raised for charities as a result of this fair?
It's anywhere between $500 and $1,000.
And to whom were the monies donated?
Every year we pick a different charity. It's been to the American Legion, it's been to the Animal Shelter, it's been to the chorus at the high school. I can't recall.
Okay, that's fine. Thank you very, very much. Is there anybody else who'd like to be heard in this application? And seeing no hands, we're going to call an end to the evidence of this particular hearing and discuss this application in open session. Mr. Mullins, you want to be heard, sir?
You know, when we first started hearing this, I did make a suggestion that this be a multiple-year permit, but
Could you do me a favor, Jeffrey? Could you speak up just a little
being
bit?
thoughtful, John.
So everybody in the,
Just trying to be thoughtful.
well, we want to hear your lucid analysis of these complicated
I
facts.
said one time a couple of years ago that I thought this should be a multiple-year permit, but after hearing the testimony and reading Attorney Dunn's letter, I think we need to keep it to an annual permit for all the reasons that have been stated, despite the fact that it requires another hearing. I don't see why it would require additional cost for the event. I heard testimony to that. That doesn't make sense to me.
There's a filing fee for the application.
Yeah, okay. I heard costs to the artisans, that it not be an annual event, that it be a 5-year event. I think there's additional bureaucracy, but I think the facts of this particular circumstance that we've sat in multiple hearings over an extended period of time now, and this matter is being heard in multiple jurisdictions, requires that we do it this way. And I would support an issuance of the special permit along the lines of last year's special permit, with the exception that I think it should specifically require a detail, and it doesn't now. It just says you have to coordinate with the police. So I think they got to have a detail up there. And the fact that they had a detail before, and the testimony of the size of the crowd, knowing the neighborhood, it seems to me to be reasonable. It's not onerous, but I don't think the permit specifically requires a detail as written. It only requires that you coordinate with the police and the fire. Okay. So I would just offer to the board that modification. I mean, because it's consistent with Attorney Dunn's letter.
Can I say something about that?
Well, I guess we're trying to decide the case.
No, I just wanted to say, I don't have a problem getting a detail, but as you know how the police work, you call in a detail and request a detail. A detail doesn't always show up. So we have requested a detail every single year, but a detail doesn't always show up. If Milton doesn't have one available, sometimes they send a detail from Randolph. We had a Randolph detail
Really?
before.
They don't have
So-
cadets or...
No, so
Oh, drawdown, it's a whole call.
So
Complicated.
we always call and request a detail, but I don't want to be penalized if the police do not send one.
Right, I think you should just call them well in advance, and if they indicate they can't get a detail, maybe the state police, or they should have people who are available somewhere.
I think, yes.
You would think so. It's
But so I just want to, on record, even though a couple years ago a detail did not arrive, it wasn't because we didn't call to request it.
okay, thank you. Mr. David, do you want to be heard?
Yes, thanks. I guess my train of thought is fairly similar to Jeff's. Back a couple years ago, I was actually in favor of doing it for 1 year, and this year when I first looked at it, I was thinking, well, maybe it should be multiple years, 3 or maybe if not 5. But again, hearing the testimony, I'm a little bit troubled, and I don't disagree with having it for 1 year. I'd definitely do the 1 year, but I think this time maybe 1 year again. And again, bearing in mind that what you said about not always being able to get a police detail to couch the permit that way accordingly, like if available, or request a police detail or whatever. No? No? Okay.
I don't
Always get one? Okay.
I've had a lot of experience with police details, and I think if you call sufficiently in advance, we can find somebody from the Norfolk Sheriff's Department or the City of Quincy or somebody to fill that detail. I think there's plenty of officers looking for details in the holidays. So I don't know. If the detail doesn't show up, there's a process for that.
I will defer to your superior knowledge.
It really needs
about
to say,
police
and
details.
it doesn't
All right.
say there's a detail now, and I think that's, I was up there in 15, and it's a busy day. That's fair. That's why I asked Mr. Rowe the question.
I had thought it did say that, but then when I went
Right, say
back
it,
and
yeah.
looked at it, right, yeah.
I think it inferred that. I think the language infers it, but knowing I think there's been establishment that the detail, and I think the neighborhood, I think it calls for it that day.
Yeah.
And I think the fact that the Thea staff is out there, I think that's very helpful, but I don't think there's a replacement for that cruiser.
No.
No.
Well, my view is that I agree with my colleagues. I really would like to see everyone get together and make joint decisions, but that hasn't been the record. My concern here is that this fair has become an event in the community. We recognize that. Mr. Johanning and Mr. Rowe recognize that, even though technically it may be a little bit of a stretch under the bylaw. It's a family event and money goes to charity. My view is that since they're not opposing your fair or your annual boutique, that if we did allow a 5-year or a 3-year or 2-year program, even though it could be limited and changed if there were real problems, I'd hate to see an appeal of this boutique in the Superior Court because we gave a 5-year or a special permit. I think it wouldn't be in anyone's best interests. In fact, I think it would be an accelerant to the relationship between the parties. So I agree with my colleagues and I agree with Mr. Mullins. I agree with Mr. Mullen when he suggests that we should specifically say that there should be a police detail there. I agree to grant the special permit, the limited exception special permit, as we call it, for a 1-year period, and hopefully, with the passage of time and with the parties kind of working together, we may be able to entertain something a little longer at a later date, but I don't want to put you through an appeal that's not necessary, okay? So all those in favor of granting the special permit with the conditions we've discussed for a 1-year term? Say.
Yes.
Yes,
Do we need to say what the date is, or?
Well, the date is in the application. It's all in the application. It's the first...
Oh, it's just the first Monday, okay.
the first
Just say
Monday.
the first Sunday, rather.
Yeah, it's in it's in the application, so
I don't think a
that's fine.
specific date was there.
It isn't.
Yeah,
It isn't.
But that's okay.
December
The
3rd.
first,
December 3rd, yeah. So congratulations on your special permit, and thanks for coming. And Mr. Johanning and Mr. Rowe, thank you for your courtesy and not objecting, and hopefully everyone will have a nice time. Thank you. Yeah. Okay. Thank you very much. Have a good night.
Patriots are on at 1.
On that day?
Yeah,
What do you know? Who are they playing?
playing the Bills at Buffalo.
Well, that's watching probably 10 minutes of football and then
I don't know, the Bills are doing pretty good this year.
wasting your time.
Jeff, a few pieces of blank paper that I can... I forgot to bring a pad.
I tell you what.
Okay, do you want me to write this? I will. I don't care, whatever you want. There could be more complex applications that you may want to write rather than...
On this one, though, we'll just issue the special permit. We don't need a decision, do we?
Oh, I think you need a decision.
Just like last year?
Yeah, it's-
Thank you. I'll give it back to you.
do you need some paper? What are you going to use?
I don't want that, I'm totally...
They're in Buffalo on the 3rd.
Yeah, that's what I said. Yeah, at Buffalo. Yeah. Sunday at 1. John can stay home.
You don't need it.
He doesn't have to leave. That's good. I felt bad to leave his house. He can stay home, watch the game, he'll have fun.
Okay. Mr. Mullen's going to take a shot at writing that decision. Thank you, Mr. Mullen. Oh, that's all right. Oh, sure. Okay. Okay, we're going to call to order our second and final hearing of the evening. This is the 7:45 hearing at 8:16 in the evening. This is the application of 131 Elliott Street LLC. The application is dated September 14, 2017, and as advertised, the applicant is looking for three variances in order to develop a mixed-use building, which is supposed to contain two 1,000-square-foot offices on the first floor and two-bedroom apartments on the second floor. The property's at 475 Adams Street in Milton, which is located entirely in a residential C district. The use regulations do not permit this type of mixed use in the Residence C district, so the applicant is looking for a use variance to construct this property, and the proposal is that the building on the proposed development plan be set back from the front property line by 12 feet, and there's going to be a canopy. Maybe it's changed at the present time. It was going to be about 4 feet from the lot line, so we'll see what the latest development plan shows. And the applicant was looking for a setback from the rear property line of 5.5 feet rather than the 10 feet required under the bylaw. My name is John Leonard. I'm chairman of the Board of Appeals, and with me tonight to my immediate right is board member Ted Daber, and Jeffrey Mullen is to my immediate left. The rules of the board are going to be the same as the first hearing. We'll hear the applicant, we'll hear people who want to speak in support of the application, we'll hear people who have questions regarding the application, and we'll see if anybody has any objections to this application. So as evidence for the hearing this evening, we're going to have the application. We're going to have a denial letter by Mr. Prondak. It's dated September 12, 2017. And Mr. Corcoran has filed, as he always does, a fairly extensive memorandum enclosing a lot of plot plans and proposed plans and plans of the area and GIS website materials, and a rather lengthy discussion regarding the requests for variances and why, in his opinion, they should be granted. And we also have received a whole series of plans. They're from McGrath Architects, showing the proposed building, proposed mixed-use building. They're in multiple sheets. We have a site plan. We have a plot plan that's prepared by Robert E. Hannigan and Associates, a name familiar to the board. And we have an existing site plan showing the building that's presently there. And we have ground floor plans and a second floor plan and a front elevation plan and an end elevation plan and a building section plan. And we also have a rendering of the proposed property. It looks like some type of a computer rendering, which also shows Mr. Jubinville's property to the left. And we have a GIS map showing the subject property and the surrounding property. So we'll have all of those as evidence of at the hearing. We also have received a letter from the Milton Planning Board. It's there it is. Thank you, Mary. It's dated October 4, 2017. It's a reasonably detailed letter. I'm really not going to read it verbatim into the record, but I'm just going to summarize it. It's from the chairman of the Planning Board, Alexander Whiteside. And before I read the letter, I really do want to express the Board of Appeals' appreciation for the pre-site plan review of this property by by the planning board. I was just very impressed. They did not short shrift this. It looks to me that they spent approximately an hour reviewing Mr. Corcoran's presentation and going through the various issues that they saw. I thought it was very thorough and comprehensive, and so I just want to thank them for their time. They did that as a public service. It wasn't as something that's technically required of them. And likewise, I want to thank the Board of Selectmen, who had another hearing regarding this and listened to Mr. Corcoran's presentation and made some thoughtful comments as to what they believed. And I think that all stems from the fact that this is a request for a use variance, and use variances are begrudgingly granted. And it's very important for the Board of Appeals to have the proposal for the use variance vetted before the planning board and before the Board of Selectmen, so that the Board of Appeals has the benefit of their insight and their judgment. We're technicians when it comes to dimensional variances and the like. We really don't possess a lot of expertise with respect to site planning or architectural issues. And if you, I'm sorry, did you have?
No.
And if we have to get involved in that, it's really important that we have the benefit of people who are experts. And so thanks to the planning board and Mr. Whiteside, Chairman Whiteside, and certainly thanks to the Board of Selectmen for their thoughtful time regarding this. So in essence, Mr. Whiteside's letter to the board indicates the nature of the proposal that has been filed by the LLC developer. They note that Stephen O'Donnell of the Milton Historical Commission, I don't know whether Mr. O'Donnell is here this evening or not, that he talked about the significance of the existing structure and the concern of the Historical Commission regarding the massing of the structure, as he puts it, on the site. Chairman Whiteside indicates that the majority of abutters who actually attended this hearing and spoke supported the project, but there were a couple of concerns over aesthetics and traffic impacts. Mr. Whiteside believes that the issues that really need to be considered by the applicant is to address the flatness of the massing of the structure through architectural design features of various iterations, which he puts in the letter, talking about the setback, the parking being tweaked here and there in order to perhaps allow a setback of the building or to get the parking more away from residences, to provide structural and vegetated buffers on both sides, to protect open space for the new inhabitants of the building if this proposal is allowed. And so the letter concludes that the planning board finds the proposal to redevelop the parcel to be appropriate given the site's history of commercial use and the context of the surrounding Milton neighborhood. And if the Board of Appeals chooses to grant the requested variances, then the planning board is recommending that the variance decision make clear that the proposed development will also require site plan approval by the planning board. There's no question that this does require site plan approval, and with respect to the history of some of these projects, it's not unique for the Board of Appeals, if it decides to grant the requested variances, to send this matter back to the planning board for site plan review and for the modifications that they think is necessary, and to incorporate those site plan review considerations as conditions to the variance, so that there's no mistake as to what is supposed to happen if the development goes forward. We also did receive a letter. This letter is dated, well, I think the letter is is undated, but it was received October 12, 2017, and it's from George and Hillary Lambert of 36 St. Agatha Road, Michael and Jessica Sergi of 462 Adams Street, Martin and Kathleen Shields of St. Agatha Road, and Tom and Annie Zukauskas of 23 St. Agatha Road. I'm not going to read this letter verbatim. The Lamberts, the Sergis, and the Shields and the Zukauskas people, are you here tonight?
Sergi is there.
Okay, then that's fine. So, but in essence, the letter says they oppose the particular application for variance because they think it may involve increased traffic, make the walk to the square treacherous, commercialize this part of town, make the parking situation worse in the square. And they have two specific comments. They criticize the application. I say that lightly. I don't mean in a vile sense, but they suggest that the application doesn't specify the types of offices that would occupy the first floor. They don't refer to them as professional offices, or more specifically define the use, and they don't think that's appropriate, and that they say that other homes in the neighborhood, the comparison is not appropriate. They think Mr. Jubenville was granted a special permit to allow his use. I don't think that's accurate. I think Mr. Jubenville was granted a variance to allow that particular use. And they do indicate that this proposal is fundamentally different from other variances that were granted in the area. They think this is especially troublesome because of the construction on the East Milton deck and some proposal about 70-plus units in East Milton Square. So they ask us to deny the application for variances. So I think unless, let me just make sure, we're tape recording the proceedings as always. Speak up, tell us your name and address before you speak. And I think that's just about it. I haven't missed anything, do you? Okay, fine. So, Mr. Edward Corcoran, welcome back to the Board of Appeals, a familiar voice. You've been a busy man of late.
Thank you, Mr. Chairman and members of the board. I have been a busy man. I haven't been before this board in a little while.
Yes.
However, so I appreciate
I shouldn't say we've missed you, but I think
Appreciate the opportunity.
it's good to have you back. Why don't you tell us about this application and what its present status is, and what type of relief you're seeking, perhaps other than the advertised relief.
Sure. Thank you very much. I am joined by Stephen Conley, who is the principal in the
Hi,
applicant,
Mr. Conley.
131.
Welcome to the Board of Appeals.
And Robert Hannigan, who is the engineer, has drawn the site plan.
Who's he? Mr. Hannigan has been here before I was born, I think. Welcome back to the... Nice to see you again, Mr. Hannigan.
So this is an interesting application for variance. I have some amended plans to hand you, and I'll do that shortly, but I thought I would spend a couple of minutes initially on the area and the history of the area as I lay it out to some degree in written materials. But in the aerial map, or the GIS map that I gave you, shows the property in question. It is a rectangular lot that fronts entirely on Adams Street, and a section of Adams Street that is pretty high traffic volume. There's actually, this aerial is slightly inaccurate because there is a stretch of the property that's along the boundary with the Jubenville property that was actually broken off by Robert Jubenville. 5 years ago, Bob Jubenville bought this property. He divided it. Mr. Hannigan actually prepared the A&R plan and carved off about 20 feet of frontage on Adams Street and added that to his lot to enhance his parking. And so the aerial is actually a little inaccurate with respect to that, didn't catch up with that. But the property itself is 15,000 square feet and change. It has more than, it's got about 300 feet of frontage on Adams Street. It is capable, under current zoning, of being divided into 2 lots.
Can I stop you just once? Can everybody hear Mr. Corcoran? Okay, that's fine. Go ahead, Mr. Corcoran.
So it's capable of being divided into 2 lots, and therefore have 2 single-family dwellings on the lot. But it's hard to think about how you would place 2 single-family houses on smaller lots with poor access and egress in and out of Adams Street and to do that. The Jubenville property, as you indicated, is a mixed use. There are 2 apartments upstairs and offices downstairs for a number of lawyers and others. I think there are at least 5 lawyers and 1 non-lawyer who have office space on the first floor of the Jubenville building.
Are they independent contractors, or are they part of Mr. Jubenville's firm? Or,
I think they're all somewhat independent. I'm not sure, to tell you the truth. I know that the non-lawyer has his own office in there.
What's the nature of his business? This isn't a pop quiz, I'm sorry.
He's in the wind, solar energy
Okay.
business. He's a consultant. He was a consultant to the town a while ago with respect to that. So he's not.
What's the nature of the apartments in the top portion of the
Small units, apartments, 2 separate apartments on the 3rd floor.
Are they leased for
They're leased.
a year or something like that?
I don't know the nature of the leases. I know that they're leased. I know that the town records indicate that there are 2 apartments plus office.
Okay.
That the finished area within that building is almost 4,700 square feet, which is approximately twice the finished area that's being proposed in this building. It is a larger building.
Did you say 47?
It's 4,691.
Okay, thank you.
square
40.
feet.
I didn't pick that up. I was thinking of something else. Thank you.
So the finished area is almost 4,700 square feet. This building is proposed as 2,000 square feet of office space, 2 1,000 square foot offices on the first floor and 2 small apartments on the second floor and approximately 2,000 square feet. So a total of about 2,000 square feet, 2,500 square feet of, strike that, it's about 4,000 square feet. So it's slightly smaller than what exists at the Jubenville building. The Jubenville building on the right is an office and mix of residential. There's a church on the corner of Babcock Street on the other side, and behind it there's a small residential neighborhood with a 2-family, and a 1-family. The post office is the next one over towards the square. Directly across the street is the Blue Hill Bank building, which exists by variance. It's a former residence that was converted to an office building by variance. It was recently acquired by the Blue Hills Bank and modified under site plan approval only because the prior variance authorized a bank as one of the uses within that property.
Do you know when the first variance was issued for the so-called bank building?
It goes back to the 50s and the 60s.
Okay, I think it was 1943.
Okay.
So why don't you go on with your
I know that
presentation?
down to Squantum Street, which is just off the map, is an office building that was approved by variance when a car dealership closed and a gas station closed. There used to be a gas station and an automobile dealership on that corner. Between them is St. Agatha Church and St. Agatha School and some residential areas. It is an area that is fairly high volume of traffic. It is commercial in nature, although has not been zoned as such. And this use, I think, is the use that is most consistent with uses along the stretch and is the most logical one to think about. It is really illogical from a use perspective to think of a single-family dwelling in this property sitting between a church, an office, and across the street from an office. And so I think the nature of the lot, the situation of the lot, the way the lot sits between other uses that have been approved by this board with variances over time would render it appropriate to issue a variance in this case.
Do you have any evidence, Mr. Corcoran, from any realtors or land use planners or developers, other than your own client, obviously, that the subdividing of the lot and using it for two house lots is not reasonable, it's not feasible, and it's not economic? Do you have any?
My client's in the business, and they've determined that it is not feasible to do two single-family house lots. To think about putting two driveways on that small stretch of roadway.
Or do a common driveway?
You could do a common driveway. The thing I would suggest is every strictly residential property in the area fronts on another street. Doesn't front on Adams Street. You're not coming in and out of a very busy stretch on Adams Street with a small station wagon or minivan with children and making those ins and outs all day long. That's a higher volume traffic use than a use that would have a small, quiet set of offices where people come, work for the day, and leave. Maybe receive clients over the course of a day with an occasional in, an occasional out, coming for a business purpose. And then two small apartments upstairs where the occupants are there in the evenings, predominantly, and on weekends. And there is we do know, and I know from other situations, that there's a demand for two types of small apartment dwellings: young professional singles and couples, and empty nesters who are looking for places to downsize to, sell their homes, and move into small apartments. Walk to the square, walk to the amenities that are in the square, and perhaps pick the bus up, take the bus to the trolley, or to the over to North Quincy, take the T in and out of Boston. So it's an area that lends itself most specifically to the use, and I think it would be a hardship to say that you would try to figure out how you would craft two small single-family dwellings that don't fit within the area. So we have, as you indicated, been through a fair amount of process with this. The property was purchased a number of years ago, as I said, by Robert Jubenville. He sold it to Tom O'Neill, who filed a previous application to put a small a commercial real estate office in the property with residents upstairs.
This is in the property as exists?
The property as it exists.
All right, okay, all right.
In the course of that process, he tore out the inside of that property, assuming that he would get approval to put his office there. There was opposition at a hearing before this board, and he then hired me to represent him, and we withdrew the application. And it was
Was it withdrawn after a hearing?
It was withdrawn after the start of a hearing. Hearing was continued. He had Bob Sheffield represented him at the first night of the hearing. For reasons I'm not, they are what they are. He hired me. We started to take a second look at what process we might do. The board had continued the matter. We walked in and withdrew.
Do you know when that hearing was approximately?
About 3 or 4 years ago.
Okay.
We then spent a little bit of time thinking about reintroducing it with a neighborhood process. And he decided, for reasons I'm not quite clear, that he just didn't want to go through that. I know that his wife is the former superintendent. He didn't want to put her through a process publicly, and so he decided to sell the property. He was going to rent upstairs to his son and have his own commercial real estate office downstairs. When he sold, before he sold, he had essentially completely gutted the inside of the property and substantially left it open to the weather. So we went through a process 2 years ago, culminating in a hearing with the Historical Commission last February, where the Historical Commission sought to have the Conleys retain the building and reuse it. and they just weren't able to do it. It was in such poor condition that they couldn't do it. And the building, as you see from the existing condition site plan, runs essentially all the way back to the rear property line. And so it's a building that is set all the way back to the two abutting homes that are in the rear. Prior to Mr. Juvenville's purchase of the property had been historically used as doctor's offices. Special permits were granted to Dr. McAuliffe in the 60s and the 70s. There's no record that I could find of additional special permits, but Dr. Dan Driscoll had an office there for many years, and so it has been used historically under permits for commercial type use, and never has been used, or hasn't been used for a long time as strictly a residential property. And although it is within the residency zone, it has never been used, or it hasn't been used for a long time, as I said, as strictly a residential property.
When it was used for dental office purposes, do you know approximately how many parking spaces were on the property at that time? Was it approximately 8 or 10, something like that?
Something like that. As you drive into the driveway, to the rear, there's a barn in the rear of the property, and there's a series of spaces off to the left. There's also on-street parking and a fair amount of volume for visits to the post office and others that use on-street. The parking under zoning, and we pursued parking under zoning in this case, would require 8 spaces for the 2,000 square feet of office and 1 per unit for each of the 2 units. That requires 10 spaces. We thought about pursuing a variance to that number, understanding that there is a real parking sharing that happens, that spaces that are used for offices during the day can turn over for residential in the evening. You might not need the full volume of 10 spaces, but we thought we had room to create those 10 spaces, and so we would do that. And with that, I'd like to hand out some modifications, because one of the things that we discovered in the process of meeting with the planning board 2 weeks ago was that we could adjust the layout of the parking lot to avoid the need for variance.
Let me just ask you one question. Do you folks out there, do you have copies of this revised plan? Do you have an extra copy, Ned?
Yes.
That you could share with other interested persons back there? Okay, why don't you continue, Mr. Cook?
So we have a green-colored version of a revised plan. You can see hatched in red is the existing building, comes front to back, and the proposed building on the front. We've had, as I said, a fairly significant amount of process. We did meet with the neighborhood 2 years ago, a couple of meetings, in an effort to talk through this idea of a plan. We went through the historical demolition delay process. The Historical Commission did issue a demolition delay. We've waited that out. We're well beyond the 9 months associated with that, and so that is no longer in effect. And we went before the planning board in preparation for coming before this board, understanding we'd need to go back to the planning board for formal site plan approval. The earlier site plan showed 10 parking spaces, 5 up against the building and 5 to the rear. On the right-hand side, rear, the space closest to the right side lot line was 5.5 feet. We discovered in the process of discussion with the planning board that Mr. Hannigan had actually drawn those spaces, that parking area, to be larger than what's required under the town zoning bylaw. So each of the spaces was 19 feet in length rather than 18 feet. And the drive aisle between spaces was 25 feet rather than 22 feet. So by shrinking the parking spaces to 18 feet and shrinking the width of the drive aisle to 22 feet, we now have more than 10 feet setback to the closest point in the rear, on the right side lot line. We no longer need the variance for that setback. And the neighbors, particularly the Stocks and the Fitzgeralds, who own the two-family that is immediately behind the property, and were at the planning board meeting, and unfortunately are not able to be here this evening. They were planning to be here to speak in favor, and we got a text from Mr. Stock just a little while ago saying that there was a death in the family, and he is not able to, they were not able to be here tonight. But they were pleased when we were able to shrink down this area. There was a discussion, there was a suggestion made at the planning board by Mr. O'Donnell from the Historical Commission that the building should be turned on its axis and run lengthwise into the property, which would have brought into play the need for, I think, side yard, front yard, and rear yard setbacks, and would have brought the building much closer to the direct abutters to the rear. And they objected to that. We certainly didn't want to make a change of that nature and have to re-advertise the relief that might be requested before this board. And we thought that that because of the nature of the building, that it ought to meet the street. It ought to have a presence on the street. The suggestion from architects on the planning board was to change out the front appearance of the building. So the building as rendered has a very small nose to it with a small eave overhang over the front door. This has a fairly wide, long plane as it faces Adams Street. So I came up with the idea, which is shown on the new version of plans, but don't have a new rendering, to widen create a much wider porch area and a much different feel to how the building faces the street. It's within the same setback, so I don't think we don't need to adjust the relief from the front yard setback. It's still 6 feet off of the front lot line. It's interesting that if this were in the business zone, it's not, there would be no front yard setback. The business use, we would suggest, is more appropriate coming towards the street. We think it's appropriate to grant relief from a front yard setback, which would otherwise be 20 feet, and push the building substantially back towards the rear of the lot. And so with those two major changes, those were the two major issues that were arrived at with the planning board. They had questions about the makeup of the green space. One of the interesting things is that also with respect to how the parking might impact properties in the rear is that there's a fairly significant grade change as you come from Adams Street towards the rear. It rises about 5 or 6 feet. And by
It
leveling-
rises as it's going back in the property?
Up into the property.
Into the property, right.
And so the plan is to install a retaining wall to lower the grade of the driveway and the parking area in the rear, and to install a retaining wall with green space behind it with a fence and other plantings behind that. And that will reduce the effect, if any, of headlights that might come in and head towards the rear, towards the Stock residence in the rear to the rear of the property. They appreciated that. They thought that was appropriate. They've put a fence in along the property line. Their fence actually encroaches a little bit into the property itself, but the Conleys and the Stocks have spoken specifically about that. They don't have an issue with that. There's discussion about the nature of a couple of trees exist to the rear that the planning board is interested in. And so specifically going back to the planning board would be to deal with the finalization of how the site plan works relative to its neighbors. So at the end of the day, as I read the concerns of the neighbors in the letter that was sent, I don't see how any of those concerns specifically either demonstrate how this property would affect their property. They are all on the other side of St.
Well, I think they're talking about the district more generally than their specific property.
And I agree, and that's, I think, a larger issue than what this has. I don't see how a redevelopment like this, of this property, that's somewhat consistent with its prior use, is going to have a significant change in how the district operates.
Do you think that their suggestion that the nature of the office use be more specifically defined has merit?
I think that's reasonable.
For example, if you just said office space, well, you could have a fortune teller set up an operation there. And I don't think anybody would think that that's enhancing the square or Adams Street or anything else. So doesn't that make some common sense?
No, I think we're, and we said in meetings previously that, professional offices is an appropriate use. If the
Well, I think
board
they're
were to
saying
vote this-
you didn't even ask for professional offices.
We asked for office, which is a low-impact commercial use relative to retail or other types
What
of.
if one of these cyber gambling operations or something? I don't know whether that's still lawful in Massachusetts. You wouldn't want to see that there either, would you? DraftKings or something. No, you want something that's in keeping with the neighborhood.
And
Sure.
And if the board sees fit to grant relief and to limit that office relief to a professional office relief, that would be fine.
Okay. Let me ask you a question that concerns me. And I'm not a land use planner. And maybe Mr. Mullen has expertise in this area. He's the fancy real estate lawyer in a big firm in Boston, so he sees a lot more of this stuff than I do. But when I looked at this originally, without hearing from anybody, I looked at the building and said, wow, isn't that walling off Adams Street? Such a big structure. And then I heard some comments, I think it may have been from the applicant, saying how this was somewhat of a similar type operation or building in architectural style and dimensions to Mr. Jubinville's property. Maybe there's some points up at the windows of that. But apparently the Historical Commission had an issue with the massing of the building, and they wanted the building made perpendicular to the street. You agree with me, don't you, that if you did turn the building perpendicular to the street, that there would be less of a massing effect? Do you not?
I do.
I'm not saying whether it's appropriate or not, but certainly
Yes.
it's hard to look at the present structure. It's hard to find it. You see the little porch there, but you really can't see it unless you walk to the side and you look back in there.
I do agree with that, but I think relative to the impact of the building that gets turned on its immediate abutters to the rear, that it is much more appropriate to mass that building the way it's massed to the street than it is to turn it and to have that building sit right up against the rear lot line.
But why is
I'm
it?
not sure how you would park that building relative to the triangular nature of the site. It would be
No,
difficult.
why isn't it possible to do something that's kind of intermediate? I thought at the planning board pre-hearing, for what it's worth, Ms. Turgayas, a professional architect, I think of some prominence, was suggesting that she thought that rather than turning the building totally perpendicular, you could stage it back to some extent that would soften the impact of the building for sightline purposes and for massing purposes. And I suppose that's going to be an issue when you go back to the planning board. Do you intend to do some iterations showing that the building maybe be set back or staged in some way to try to break up that massing?
What we're showing and what we discussed with Mr. Gaius and the planning board was a change to the feature in the front of the building.
The porch.
Right.
The
A much
so-called
wider
porch.
feature with colors and window treatments that might adjust the plane of the building.
But you don't have any of those to show us tonight.
That was,
Because I actually thought, and I don't want to take over the hearing here, you know, I thought this was an interesting application, but I thought it was backwards. Normally, if you have a conceptual plan, and you want everybody's input, you go to the planning board and you say, here's our plan, they give you input, you do revisions here or there, you tell them what you can do, what you can't do, and you go to the selectmen and you show the selectmen, and then you say, well, now we have our plan, and we can put this together, and then you file with the Board of Appeals. But this whole process has been in reverse. You filed with the Board of Appeals, and then you've been running around to the planning board and the Board of Selectmen, but you kind of locked yourself into a site plan here. And my question is your site plan, as shown here, is this your final and definitive plan? Or is this an iteration that you're going to take back to the planning board and get their input as to how to solve the massing of the project?
that's pretty close to the final site plan relative to how the building is going to be constructed. Because if you're going to move things back and forth, now you're changing out the foundations, you're changing out where the parking lays out. And no, we're not,
Why aren't you doing that to see if it works out
because
on a conceptual basis?
because I think the Conleys have determined that this is the most appropriate building that they plan to build for the site, and it's what they've asked to go
Yeah, but
forward.
isn't that my way or the highway type of
I think,
approach?
excuse me, I think this,
Sure.
the site plan somewhat reflects what Cheryl's, two guys had talked about, showing an expanded porch and a little bit of relief from the front of the building.
Right, but I thought her principal concern, but I certainly haven't talked with her. When I heard her, she was concerned that the building should be staged back, should be set back in some modest way. And she wasn't suggesting, I think, that it be put 15 feet or 20 feet back. And I guess that's what my question is. We're not site plan people, okay? But it seems to me.
I think that might have been her initial comments, but then, as my sense was, as the discussion evolved, then there was the talk of expanding the size of the porch and providing relief in that regard.
Well, that may be. I think that's the way I remember it.
That's where I feel like we netted out in the discussion with the planning board about how the building might be adjusted relative to the concerns that were raised by the Historical Commission, relative to what
Well, it
the
just doesn't address the Historical Commission at all. It does
we don't, and-
the absolute opposite of what they want.
Strike that. It was Steve Kahn, it was the chairman of the Historical Commission,
Is it Mr. O'Donnell?
O'Donnell, who
Yes.
came on his own.
Well, he may have. He was speaking for the... He wasn't speaking personally. He didn't say he
We
was
weren't
speaking
invited to a
personally.
conversation with the Historical Commission about how they might react to the application as filed.
Okay.
We had a difficult process with them.
Did you solicit their contribution
No,
on this plan?
No, the only plan that we solicited was relative to whether we could save the existing building.
Right. And they wanted you to try to
They
save it.
wanted
and
us
you
to try
couldn't.
and save it, and they wanted us to try and incorporate the front portion of that building into a larger building as proposed. And we said we couldn't do that. So the building was not sufficient and not able to do it. Structurally, physically, and could not be readjusted. The ceilings heights are low, they're in poor condition, the floor plates are in poor condition, the foundation's in poor condition. The building is not salvageable. And so the alternative is what was proposed here. It's a fairly simple, fairly basic building that mirrors what's next door and comes to the street. And we thought that that was a more...
What mirrors next door?
Essentially, is very similar to the building that Bob Juven built.
Mr. Juvenville's building, it looks like it's 35 or 40 feet from Adam Street, isn't it? It's not on the street.
It's on a completely different lot that is...
Of course it is.
That is cornered on...
That's why his development is completely different. It's nothing like this. I don't see how anyone can say that this is trying to replicate what Mr. Jubenville did over here.
We're not saying it fits...
It's got a peaked roof in a little area, that's all.
Similar appearance of windows, appearance of the nature and style of the business. It's a different building. It's designed by a different architect.
Well, right, it's an entirely different building. I don't think it's similar, and maybe my colleagues will disagree with me. This is a massive structure. It's... I understand why it may be economic for the developer. All I'm trying to get to, and I'm not being a land planner. I'm not a land planner. Whether the applicant, I say you, but I mean the applicant, has considered some type of iteration that would set back a portion of this building, 2 feet, 3 feet, 4 feet, whatever Mr. Hannigan would suggest, or what Mr. Gaius would say, that would take that facade of the building and would soften it. And so my first question is, have you considered that? And I think the answer is no.
The answer is yes.
Okay, then-
And the answer after considering it was no. And the conversation with the
Okay, well, let me ask you this then. Do you have a plan that you're going to be able to show Mrs. Tugayas at the site plan review that is going to show this building being staged back from 3 or 4 feet on one end, and to show that it doesn't work and that you can't get the parking in, or you're going to so infringe on the 10-foot? That's what I want to know, whether you have that.
Mr. Chairman,
Sure.
Member Tagaya suggested the step back in response to Chairman O'Donnell's from the Historic Commission concern about putting that
She
building
did,
on there.
yes. She was trying to compromise, so make some reasonable.
But during the course of the discussion, that's just a 4-unit building. It's a simple, I think it's 34 by 78 blocks. Once you start, and we had this discussion with her, once you start jogging that building back, you're creating space that you cannot use in that building because of the way the floor plan lays out with the common halls, et cetera. The other thing is, it was Mrs. Tagayas that suggested the porch after we said that we would not do that, and she suggested elongating that porch and putting a hip roof on
Yeah,
it.
that was discussed. I agree with
And that's
you.
what we've done.
But you didn't have a sketch of the porch because it had just been
Well, we have it in this
brought to
package.
your attention.
We have it for you tonight, but we didn't have it for her. But it is on I think it's L3 of the package.
We also discussed the impact that stepping would have on what limited green space there is on the property.
On A3.
A3.
Yeah.
So it shows that new entranceway.
So if you're right, you may be, Mr. Conley, I don't build buildings. I mean, that's one of the problems here. You get involved in the variances that we get involved in, and you get the planning perspective of the planning board.
Sure.
Who are skilled and expert in this. Does it make any sense whatsoever to take the building as proposed and just tilt it a little bit, make it go back 2 or 3 feet, or give it an angle? Does that? You could talk to Mr. Gaius about that. She may say that's stupid.
Well, my experience with buildings, and especially with where this is on Adam Street, you have that retaining wall that was created when the highway was cut in, that they went right up against the property line, and that's where the building is right now. To tilt that building, what you're doing is you're pinching the back parking area. Because we need what we have now. What we want to do is satisfy the neighbors in back. We've pulled this back that we don't need that rear.
So you don't think angling the building to any degree?
I don't think it'll look good.
You think it will look worse?
It'll look worse.
You may be right. I don't know.
It also, he's right, there is a retaining wall along the front. If you start to angle the building, shift it back, what limited reasonable green space in the rear really gets affected. And that gets pinched. And so,
And that
the
retaining
idea
wall
was
would
to
highlight the offset, because it'll be from nothing to a point.
Well, let me ask you this, then, Mr. Corcoran. I mean, I assume Mr. Gaius is going to go through this with you in a more professional way than I have. Maybe a more sensitive way than I have. But do you intend, as part of the site planning review process, to... I noticed, and I have to say, I don't really understand this, but it must be true. She said you can change and vary the color of the siding in various regards, and maybe the size of the siding can be tweaked and changed, and that apparently has some type of visual effect, breaking up the building so it doesn't have the same massing.
Yes.
adjust windows.
Right. Whatever she suggests. Are you going to be working with her in that regard to come up with that? Okay. Why don't you continue with your presentation? Unless you're finished, that's fine.
I think I've ready to close my presentation.
Okay. I hope I didn't upset you or confuse you with my
No,
my questioning.
I anticipated a lot of these questions. I think they're appropriate questions. This is a permanent change in the way this property is used, but it's appropriate to way the property's been used historically. It's appropriate to way other properties have been adjusted and allowed to change historically, and it fits within the context and the character of this area, the way it's proposed.
Okay, great. Let me ask, Mr. Mullen, do you have a question for Mr. Corcoran? No. Mr. Deva?
Yeah, I have a couple. Ed, how you doing? And I apologize for asking this, because you may have been clearer than I remember, but I was trying to jump back and forth between what John was saying and looking at the plan when you were talking about how the plan changed. Are you saying there's 5 bullet points in this letter from Alexander Whiteside? Did you?
I don't have a copy.
Oh, you don't? Okay. Is that okay?
Oh, I'm sorry. Did you
I never
get?
got a copy of it.
Oh, that's too bad.
No, I never got the email had the neighbors attached to it, but it didn't open on my phone.
Take it, just the
I
bottom,
tried it
I was talking about the 5 bullet points.
We don't have to
That's
read
the
it.
only copy. I mean, that's John's copy, actually, because
If you want to take a second, read it over.
Okay,
It's really the bullet points that are the
Yeah.
main points he was making.
flatness of massing.
And I'm sorry if you didn't get this. You should have had this.
Address the flatness of massing structure through architectural design features, dormer sizes, proportion, window sizes, proportion, window configuration, trim details, asymmetry, facade and indents, widened. Most of that we can do with materials, with window design, and whatnot. We determined that we can't change the foundation elements.
right. But that hasn't been incorporated yet into
Correct.
any
We were
rendering.
before
right?
the-
Okay.
These are like threading the eye of very small needles with very thick ropes, and there's process that you try to get through. We met with the planning board in August. They had and told them we were coming back to them for preliminary site plan review. We're coming to the Board of Appeals and going back to them for final site plan review, because they can't grant site plan approval unless they have something to grant it on. They have to have.
You have to get permission to build.
Give permission to build.
Otherwise, they're engaging in speculation.
So we met with them in August and showed them the same material. Very little comment. The main comment was, at the time, was the location of the driveway, because the driveway was originally shown to be on the other side of the property, opposite, it was originally going to be over here, and opposite the traffic island that comes from the Wood Street extension, and that just didn't make sense, because you couldn't get across to the driveway. So we moved it to the other side of the building, next to the Jubenville fence. That was the main point of discussion in August. We were back before the planning board 2 weeks ago in September for their preliminary site plan approval. And that's when the issues with respect to how the building looked came up. We did agree with them that we could work with them on the issue of colors, materials, windows, and things like that. But we didn't agree that we could change the box of the building and step back the foundation element of the building or rotate the building. And we came up with an alternative preliminary design that really focused on the nosing and that front porch as an element that broke up the appearance. We haven't gone back to them yet. We're due to go back. It's advertised for, I think, the 9th, for a...
The 9th of November?
It's the...
I thought it was the 26th or 28th.
26th. 2 weeks from tonight, we're back. They're advertised for the 26th.
Okay.
We'll go back to them that night with site plan approval, and we would go back to them with some more specific information about what the appearance of the building would look like. Engage the architect.
Okay, and are they going to be sufficiently detailed as not to be conceptual plans that can be adopted as part of any decision of the board? Or you're not going to be able to do that? It seems to me they should be able to get that done.
For the 26th, and once we'll come in, the way I look at this process, if we were able to get relief here, we go back to the board with concepts, and when they decide what we come to a conclusion, and then we formalize to be part. Yes.
And then you'd be providing copies of those final drawings.
Yes.
To the Board of Appeals.
Right.
So if this variance, then we'll have specific plans and concepts that can be placed in the decision. And so you'll have a variance that's relating to the plans you're going to build and not towards some plans you intend to create at a later date. Is that right?
That's how we would say it, and so we expect the board to continue this hearing until a night post 26th.
Let me ask you this, if you got the variance, when do you expect to
Spring.
do this construction? In the spring? So you've got time, you're not, you've spent enough time on the project, I know you probably feel too much time, but the spring is adequate for your
Yes,
purposes.
correct.
The real question at the end of the day is this board willing to grant a use variance that is in the nature of what's presented, so that we have a reasonable, so it's reasonable for us to go spend the time, effort, and money
Right.
on architectural details and site plan details that respond more specifically to those concerns that get raised by the planning board. And if the board wants to delay a final decision, pending its opportunity to see and incorporate those plans into whatever decision we would write, that's an appropriate way to do it. But we did not need
I
to
agree
know
with you.
whether there was going to be a path to relief or not.
No, absolutely fair, and I think also that we don't pretend to be able to do site plan review or to decide architectural issues. We can just deal with them in a layman's sense, but that's the job of the planning board. That's why you went to them in the first instance. Mr. David, do you have any more questions to ask?
Yeah, so I'll, these other items, the other site plan items you're going to deal with the planning board then?
I think so, if I can.
Yeah.
I'll read
But I had a couple questions
I'll read
apart
them
from that
aloud.
there.
Maintain the 12-foot building setback. The main plane of the building is 12 feet setback. That's in the plan. And the 6-foot porch setback, despite the fact that we'd be widening the porch. Because the variance relates to the point of the building that's closest
Yes.
to the lot line. The planning board did want to see us retain, did not want it to retain that plane at 12 feet. Reduction of
Is that an actual porch that's shown on A3? I know you've got the roof coming down, but is that going to be used as a porch for this facility, or is that just an architectural detail?
No, it's an architectural feature, but it's also a usable porch, and there is a handicap ramp that comes up from the sidewalk on that side of the building that comes right up to the front entrance, and it's open on the left-hand side, the Jubenville side of the building, to allow that ramp up to that porch. Reduction of parking space and parking lane dimensions. Plan shows that. Provide structural and/or vegetated buffers along both sides of the rear lot line. We are in active discussions with the Stocks and their in-laws about what would go there. They have installed a fence. They're happy with the fence, and so they don't want to change that fence, but there will be other plantings that will go with that, and then retaining adequate open space for on-site for new inhabitants. And that's part of the issue of dealing with the way the building is laid out, is that there's not a lot of space back here for open space, and you can create some meaningful open space to the rear here. And so, yeah.
All right, thanks. So, and just for informational purposes, I think your memo says that there were permits obtained by the doctors, or maybe it was the owner of the building, in 62 and 74, and then it says at some point the usage lapsed. When did it lapse? You know?
Well,
I mean, how long has it been since it's been?
2 years, put it that way, which is the period in zoning when a use that's permitted.
Right, but I mean, was it 1980? Was it 2000?
Dr.
Was it,
Driscoll
you know?
was there.
You said 1970s.
No, Dr. McAuliffe was there in the
Excuse me.
60s and 70s. Dan Driscoll, who's, he's still a young man, he's younger than I am, I think, was there.
I was in that building maybe 6 or 7 years ago for a visit. So.
Oh, really?
It's about,
Okay.
Sold.
Great.
Jubenville bought about 5 years ago. It has been vacant
Why did he buy it? Do you have any idea?
Bought it to acquire additional lot area so that he could create more parking. He moved his fence, or built a
So he couldn't buy 10 feet or 15 or 20 feet? He had to buy the whole
I
McGill?
think he bought it, thought he might be able to do something with it. Decided ultimately that he got it for a good price. He decided that he wasn't going to do something with it, but he could carve out a strip, add it to his property, and resell it. And he sold it, and Tom O'Neill from Success Realty bought it and planned to put his own office in. And then withdrew and sold it, and the Conleys purchased the property.
So since then, since whenever the doctor's use stopped, the building basically hasn't been used at all?
Been vacant.
At all, okay. And then it was, at one point, it was gutted, yeah, okay. I don't have any more questions.
Okay, great. If you have nothing else to add, Mr. Corcoran, let me ask our fellows out there, is there anybody who would like to be, who either has questions of Mr. Corcoran? You can stay right there, Ned, if you'd like. Make yourself comfortable. Just stay right there. No, please stay there. If we need another chair, we'll just swing it right up there. Is there anyone that has questions of the applicant or wishes to speak in support of the application for these variances? Okay, there's no such person present. Is there anybody who yes, ma'am?
I just have a question.
You have a question? Sure, then come on up here. Unfortunately, we need to speak into the microphone, so you'll be picked up on TV. Okay?
Hello, my name is Tracy Dyke Redmond. I live at 9 Ellsworth Road, behind St. Agatha's Church.
And what's your last name, ma'am?
It's Dyke Redmond, DYKE-REDMOND. And my question is whether there is any traffic calming measures that are included as part of this plan or that have been discussed in any of the previous meetings.
Okay, that's a good question. Mr. Corcoran, do you want to comment on that?
There are no traffic calming measures proposed. We feel it's a small use. We know that Adams Street is a high-volume roadway, that significant amount of that traffic is non-Milton, but coming through. We think we're adding 1 or 2 drops to the fire hose. We've done no specific traffic study. We don't think we need to have a traffic study. The issue of traffic has not been raised. Before the East Milton Neighborhood Association a couple of weeks ago, the issue of traffic wasn't raised. They have other concerns with another larger development that's proposed in the square.
I don't know anything about that, Mr. Corcoran.
But there's no specific issues raised about traffic in this case. I think 2 small offices would be occupied by a couple of professionals. You might have 1 or 2 cars coming per hour. That's the traffic impact of that is de minimis. We have no capacity to improve Adams Street physically, to change how Adams Street would operate without a whole separate set of process that the Traffic Commission, the Board of Selectmen would need to undertake. Neither they nor the Planning Board have raised any issues of traffic and how traffic would be affected at this property, and we don't think there's any effect. So we're not proposing, nor would we agree to any traffic improvements that might be recommended.
Well, that's up to the planning board, I guess, if they think there are safety reasons. But you haven't looked at any statistics from the police department as to accidents out here?
No, I've been out there a lot. I've never seen traffic come in and out of the Jubenville building.
Well, that's true. I think what they're talking about is the nature of the traffic coming up Adams Street and taking that curved turn, and if they wanted to get into your professional office use, whether that's a safe turn or not a safe turn.
Absolutely a safe turn in and out of that building.
If you're in the building, going out is a safe turn. How about taking the turn from the expressway or that goes over the expressway?
Making the same move across that you'd be making if you're going to the Jubenville building. If you come off the Wood Street extension and you cross over, and I do it often, my office is in Quincy. I come through the square. If I'm going to the post office, I'll come around through. It's a simple crossover. It is safe. The island provides protection, and the length of those 3 lanes is adequate to allow you to make that cross.
Okay, so you've never had any difficulty
Never
there?
had any
You're driving a Hummer or one of these?
I've driven all sorts of different vehicles, and I've never had a problem. I've never seen a problem out there.
Okay, and so you don't anticipate any issue of parking in the neighborhood because they can't get into the driveway? And
No. If you are a resident or a tenant of the building, you're going to park in the parking lot that's provided, rather than try to find a parking space on street. It just doesn't make sense that you take up parking spaces on street. And there's adequate parking for the tenants and their visitors, in accordance with the town zoning bylaw, to meet the parking needs and requirements of that building. 10 spaces is adequate.
okay, do you know whether the planning board is considered in any detail the traffic issue or consulted with anybody regarding these?
The town has a separate large traffic study ongoing. They've hired Howard Stein Hudson to study traffic on Adams Street, coming through the square, crossing from this side to the other side, looking at the traffic movements. I know that my client, in another matter in East Milton, has also employed Howard Stein Hudson to do some additional traffic analysis associated with the impacts of that building. That's all under consideration. The town is working with the state, perhaps on some funding to make some types of improvements, including signals and other things, but that's a bigger town-wide planning issue that's being undertaken and led by Bill Clark in the planning department with the selectmen. It's not something that in this case, that we're involved in. The other project I have proposed is much larger, it might have some impact, and therefore we're studying the relative impact relative to other.
And so no preliminary results of those traffic studies are available, is that fair to say?
Well, yes and no. I mean, there are some preliminary results. They've been asked to study whether or not they should open the deck
To go straight through?
straight through. They determined they're not going to do that. They're going to continue to go around. I think that's...
Is that the final conclusion, or?
That's the final conclusion, because the question becomes a safety issue. How do you get in and get out of that area? The question being raised was whether to allow parking there, either angled or otherwise. Well, if you come in, whether it's from the Granite Avenue side on the east side of the expressway, then how do you get out? You have to come out and conflict with traffic that's coming this way on Adams Street, right? And so they determined that the small number of additional parking spaces that you might gain access to is not sufficient to overcome the safety and other traffic issues instead. So they're looking at issues of making Boulevard Street one-way, the angled parking in front of the Milton Arts Center, looking at a whole range of parking and traffic modifications, new signal sequencing, so that the traffic flows better and it works better. Nothing's come out that's definitive, but I know that there's a whole big study that's ongoing, and I know that they're reaching out to the state for funds to pay for it, including new signal at Adams and Granite and Bassett, and whatnot.
Okay, but your bottom line opinion is that this particular use will not exacerbate traffic issues in front of this building or in the square generally?
Yes.
Is that fair to say?
I mean, right now, the building produces no traffic because it's been vacant, but historically produced traffic because it was occupied by a doctor's office and residents.
Do you have any other questions, ma'am?
No, I have comments, but I'll...
Okay, great. Does anybody else have any questions? We'll open it up to, don't go too far. You may be back for your comments very quickly. So let me ask, is there anybody who either has comments on this particular application or wishes to speak in opposition to it?
So again, my name is Tracy Dyke-Redden. My concern about this proposal is in fact about the traffic. And I have personally witnessed accidents happening right outside where this building would be. And I'd like to dispute the claim made earlier that traffic coming around the circle right in front of the bank and going to the Jubenville office would be the same as for this building, because it's actually quite it's not that far, but this driveway would be a fair bit closer to that off-ramp. And so you'd have to cut through those, however many lanes of traffic it is, not very many. You'd have to cut through those at a sharper turn. And that's exactly where every morning there's almost an accident. It's, I walk my dog up there and I see the screech, brakes, and it's dangerous. It's really dangerous for pedestrians. It's dangerous for the people driving. And my concern is that by having the driveway where it is, that when those cars are coming out, or people especially are trying to get into this property, that it will create a hazard. So that's my primary concern. And as you said earlier, there's significant traffic on Adams Street. We all know that. It's already a fire hose. Anything adding to that, without any mitigation, my concern is that it's just going to lead to injuries and accidents. Somebody's going to get really hurt. So that is my concern.
Okay, thank you. Appreciate your advice. Anybody have any questions of that witness? No. Okay, thank you. Anybody else want to be heard?
My name is Jessica Sergi, and I live at 462 Adams Street.
Good. Welcome to the Board of Appeals.
Where is that? Where is that?
It is right, so here's the traffic island, and I'm this White House, I'm the old convent to St. Agatha's.
Right on the street?
Correct, right on Adams.
Yes.
Right in between the church and the exit ramp. So one question that was, one comment earlier was that the folks who wrote the letter, and one of the people who wrote the letter, won't be directly affected by what happens here. The one concern that our neighborhood has is that a lot of folks who, if they're coming to a commercial use and have never been there before, and I did, I went on Waze to see how they would send you. Sure. They would send you the way that everyone's speaking. So they'd send you to cross these 3 lanes of traffic. So if the person doesn't meet those 3 lanes of traffic and get into the driveway, one thing that we had discussed in prior neighborhood meetings, 3 years ago, I guess now, was that they would go through this back neighborhood, through the Hollis Street neighborhood, and circle around.
Right, they'd go up by the gas station there and take a right and work their way.
Or before there is
The post
a street.
office.
Yeah, right between the post office and Jubinville. Go up that street and through and go around. So that's one concern. Or they screw up in this circle altogether and come our way and go through our neighborhood to turn around. So that's one concern that all of the neighbors have, is the effect that people who don't live here and who are coming to a business use and get lost, they would be lost in our neighborhoods. And I know that the neighborhood behind this building has about 25 kids, and our neighborhood has another 25, 30 kids in it, all under 10. So everyone's concerned about additional traffic from people who don't live here and don't know the ins and outs of getting places. So that's our major concern. One other point I did want to make about getting into this driveway is, in addition to the ramp, you also have here is the exit to the Blue Hill Bank. So you have the ramp coming in, the Blue Hill Bank coming in, and the driveway, and Jubinville. So it's just kind of a big mess. And I think that if there's commercial use here and there are people who aren't sure what's going on, it's not going to help things. So I think that the traffic issue is a big issue that should be considered. One other, so we received the notice to come here about 3 weeks ago, I'd say. I'm not sure exactly when we got it. But there has been a history of this building, as explained by the applicant. So and I just wanted to add a little flavor to that.
Sure.
So in 2014, Mr. O'Neill applied for his variance, and he was going to demolish at least a portion of the building and put 2 independent professional offices and 1 residential unit. So he also was looking for 2 independent professional offices. At that time, we received notice of that, and several neighbors behind in this neighborhood wrote letters in opposition. And I have one of them. I don't have a lot of them, but one of them is a direct abutter. So if you look on this, this first page, the woman, McGowan, at that time, in 2014, she lived in Georgia. I'm not sure if she still lives there, but apparently you didn't receive a letter from her.
She doesn't own the property.
Oh, she doesn't? Okay.
It stops now on that property.
Oh, it still says McGowan on your thing, so I thought you did. Sorry. But I do know that she was opposed to it, and the other folks in this neighborhood behind here, we share a bus stop, and all of those folks oppose this. But I did speak with them today, and they said, well, you know, we didn't realize the hearing, you know, is that important that they could get the variance today, and, you know, they are very concerned about this traffic issue going through the neighborhood. So I do, one request I have is that I don't know exactly the process that is followed, but I do know that there are other neighbors who'd like to voice their concerns. So if there could be a postponement of the decision about the mixed use so that those folks could be heard, I think that that would be helpful. One other question I had, so maybe I should have raised it in the question period, but
That's all right. Go ahead. You ask the question.
is there a reason why the existing, what is the square footage of what's being proposed now versus what was there? And could the building you proposed be on the existing, you know, area,
You mean the footprint?
the footprint?
Can you answer that, Mr. Corcoran? You know, what's the general footprint of the existing structure, as dilapidated as it may be? Sure.
Somewhat similar, but it's not, it lays out poorly. He was going to demolish, as I understood, O'Neill was going to demolish the rear of the building.
Right, but we don't want to get involved in Mr. O'Neill's issues. That's
But basically, right now, it's a building that goes lengthwise into the property.
right.
And we're basically taking that, substantially that dimension and turning it.
But I think Ms. Surge's question really is one of density on the lot. So do you know what the density would be for the assuming the existing structure was habitable? Do you know what the density of that would be? How many square feet is that?
Lot coverage is similar.
It's just the dimensions are different. This is more of a square, and that's more of a long rectangle.
It also brings into play a building that goes back to the rear property line, proximate to the direct abutters who are in the rear, who have specifically expressed the desire that the building be moved as far away from them as possible and face up against Adams Street. We know that
Were these the people that were not able to attend tonight? Is it?
Yes, and they spoke favorably at the planning board.
We did.
And they spoke favorably with respect to this plan at the planning board, the way the site laid out at the planning board. And they're the ones that are most directly affected. I understand the questions of traffic. I think they're red herrings, but I think the direct effect of any development of this property is on the two neighbors that are behind it.
Ms. Surge, do you have any other questions or comments?
Hold on, let me just scribble down a couple of things. One other concern that the neighbors have talked to us about is the commercialization of the neighborhood in general. So as you've pointed out, you know, this building as proposed, though it's being proposed as something that's similar to Jubinville. Jubinville still looks like a home, and it's on a larger property. It looks more residential than what this proposal is, and I think folks are concerned about, okay, if there's a variance for a mixed use here, there's the law office next door, are they going to merge at some point and it's going to be a strip mall? I mean, I think that is the main concern of folks in the neighborhood.
Okay, well, strip mall is retail,
Well,
and
I mean,
nobody's proposing
But
retail here.
I'm using that, you know, I'm exaggerating a bit, but
You
that,
think there's going to be a larger combined development of the properties?
correct.
That would require its own new process and new variance.
I know another variance, or variances.
It could be allowed under what's currently being applied for.
Right. No, I think everyone understands that.
Yeah, and I think I think everyone does understand that, but I think that it's a slope. And so once there's one variance and another variance, which is exactly what the argument has been tonight, that, okay, well, the Jubenville received a variance and the bank received a variance, so now we should get a variance, and why shouldn't that just continue? And that's what the people who are actually living in the zone as residents are concerned about. And the illogical nature of it continuing to be a residence, I think, is not a very good argument. It had been used for a residence in the past, and you're actually asking for two different families to rent the apartment, so it would continue to be a residence.
Maybe millennials. That's what they're looking for, the millennial business.
Right, but the millennials might be across at the other development, so.
Well, I think you're right. I think that development is, while it's larger, the units are probably a little more suited to millennials at 400 square feet or 500 square feet, whatever it is, Mr. Corcoran, but we're not going to get involved in that. But these are two relatively small apartments, 1,000 square feet.
Right, so so my point is that it's logical to have people living there. It's not illogical to put a residence in that place. That is what it's zoned to be and what it had been in the past and what it can continue to be. And the doctor's office that was there, it was a residence with his office downstairs.
Okay, that's a good question. Let me follow up on that, Mr. Corcoran. Is it your position here that if rather than doing 2 apartments and 2 offices, that you tried to do 4 apartments? Is the site capable of supporting the use of 4 apartments? And how does that type of development involve a more intense use of the property versus two professional offices?
Just to clarify, Dr. Driscoll never lived in this building.
Okay.
So his office was downstairs, there was an apartment upstairs. 4 apartments physically could exist. There's no plan for 4 apartments, and the Conleys aren't going to...
Would you need more parking for 4 apartments of
No,
this size?
they have the same amount of parking.
Okay.
It's more likely that if you're going to strictly a residential use, you go with a much more intense residential use and park it more intensely. The
In
notion
other words, you
that
do more apartments on the site if
Correct.
you could get relief.
we do a lot more apartments on the site, because if you're going to do apartments, you're going to do apartments. And you need a lot of apartments to address the rental values and costs associated with development. And it's not, this isn't the...
So you're saying that's uneconomic?
Correct.
And that the use of 2 apartments and 2, let's call them professional offices, create the necessary economic model to allow the property to be developed?
And I think to be done in the least impactful way as possible, because the residents, apartment dwellers are there at nights and on weekends, occasionally during the day. And the office is occupied during the day. And so that occupancy flips, right? It's not all one thing and all one other thing. And it's actually a quieter use, I think, than if you had a more intense of a single type of use. I think a residential use, a multi-unit residential use would be more intense use of the property, more traffic coming to and from the property on a regular basis, would create more churn and more traffic than I think the use that's being proposed here.
Okay.
I think one of the issues that people have is the uncertainty about what the use will be. What the office
Do you have any problem with defining the use as professional office use?
Well, what is
How would you?
use? I mean,
Well, you tell me. I don't lease and make and develop apartments. What?
Me
You
neither,
can't
but, I
say
mean, does that
doctor's
mean
offices.
is that a
and you-
hairdresser? Is a hairdresser a professional office?
That's retail.
So I guess it would be helpful if the neighbors understood what professional office is and what could go in there, because I think that that's a big concern. And I know, and one issue with the way this process has gone this year is it's been very quick. And in 2005, 2014 and 2015, there were neighborhood meetings, and people understood what was going on and how things were going and what the process would be, and this has been a very quick process in the last 3 weeks, so I think people are all
They're concerned that they...
concerned and nervous, and they don't know.
And the only thing I would say to that is when we had neighborhood meetings, there was a clear, do not do this. We're going to oppose it.
That's their privilege if they
It
want
is
to
their
take
privilege.
that.
So
Was
understanding...
there any definition, Mr. Corcoran, when you were talking to the neighbors about a professional office use, as to specifically what kind of categories of professionals would be occupying these
Well,
premises?
I'm in an office building in Quincy. It's lawyers,
Does the zoning define professional office? Is there a generally accepted professional office definition in the development industry or in the real estate business?
I think nothing specific other than what Corcoran was talking about. Lawyers.
I mean, you can say, yeah, lawyers, accountants, engineers, people who are licensed in some way. Jeffrey, do you know what how to define a professional office so that people have some comfort?
I think Ted's seen if it's actually...
Well, that's right, that's right.
There's anything in it.
Good.
I did look in the bylaws, it wasn't there. It says office.
Yeah, I think that's right. I think Mr. Mullen is correct. He says that if we did research, readily available, I think, that we could come to some type of generally accepted definition as to what that meant. I don't think that's a...
We would be fine with that. I can tell you that 2 years ago, that was not an acceptable solution as we were discussing it. And we talked specifically about the nature of the uses, who would be the type of tenants. I said lawyers like myself, accountants, other professionals.
You may not be able to afford this space, Mr. Corcoran.
But accountants and for the most part, lawyers with small offices receive a client maybe one a day or two. I often go to meetings at my client's office. I might create the churn of my traffic if I'm sort of coming in the morning, leaving at 10:30 to go to a meeting, coming back after lunch.
Well, isn't that the rub? It's the 1,000 square foot. With that type of a relatively small office, it's not readily usable for meetings of 10 and 12 people, like you're a big law firm. It doesn't work. You couldn't fit the people inside.
I have 1,000 square feet. It's not much bigger than what's here. You have room for a desk, maybe a second desk, maybe a small table. You might be able to hold a small meeting, but if you have a larger meeting, you've got to go somewhere else. The library is my secondary office. I conduct lots of meetings at the library.
We should talk about that with the trustees. I'm not sure that...
Because I pay.
I'm not sure that passes muster, but...
Because I pay.
The library, you rent.
I rent this space.
You rent library space.
Absolutely. And I
I
rent
never
the
heard of
Milton
that.
Art Center when we have this meetings with the Art Center. I go to where it's...
Where it's comfortable.
And that's what happens.
Now, Mr. Mullen here is getting testy, so he thinks we're wasting some time, so he may be right. Okay, so look, do you have anything else to add, ma'am? Okay, great. Thank you for coming.
I have a question.
Oh, yes. I'm sorry, Mr. Mullen has questions.
How long have you lived there on Adams?
I have lived there since 5 years ago.
Were you there when it was a doctor's office?
No,
So you've been there, it's been vacant?
correct.
Have you seen accidents on Adams?
Yes, and I've seen people
your colleague?
come out, the wrong way from Blue Hills Bank. Because that's a one-way there.
Yeah.
Take the right. And
Take a right?
yeah, take a right down the one-way. I've
Go to
seen.
the church?
Yes. Because there is a sign there that says left, left turn only, but they still will
Yeah.
take a right. Today, leaving the school bus, a kid at the school bus almost got hit because people went through the red lights when he had a walk sign. It's just terrible. That whole area from the church to Jubinville, past Jubinville, is just a mess.
Do you think that the traffic in the premises is exacerbated by the introduction of the commercial use?
Yes.
And that it would be different if it were only residential, even if it were intensive residential?
Yes. I think that having people who don't know where they're going.
Knowledge thing.
Yeah. But I'm not a traffic study
I understand.
But
No,
that's my sense.
But you're an expert on traffic on Adams Street. You are.
In this little square,
You're the
yes.
only person who, you live right there.
Right.
And it's pretty unique, right? There's no other similarly situated house.
Right.
Right? I was interested in the way that you characterized the two different neighborhoods. So you don't think of the people behind them on the post office side as part of your neighborhood? You're part of the St. Agatha neighborhood, and they're part of, like, somewhere else?
Well, we have separate block
I don't mean
parties.
to divide you. Okay.
You're not going to have a feud here,
So,
Mr. Mullen, are we?
No, the reason I asked is you said people in the neighborhood were upset, and I wanted you to elaborate a little bit on what you meant by that.
In the
What
neighborhood behind?
are we talking about?
Yes, so I'm talking both neighborhoods.
When you said that, you were talking about both neighborhoods, but then you made other references to that neighborhood and your neighborhood, as if they were two separate neighborhoods.
Correct.
Okay, so you have it both ways, right?
Yes.
Okay, it's one neighborhood except when it's two?
Well, we're all concerned.
No, don't
but there's
answer that.
separate
No,
concerns.
Talk to your lawyer, don't answer that
It's
question.
a separate traffic pattern.
Right.
But everyone's concerned about traffic.
But other than you, it's these two people behind the property that are the closest, really,
That are
right?
the abutters.
Yeah.
Yeah, but so then there's a house, so, the church is here.
Yeah.
And then there's a house, like, across.
Kitty
so
corner from the church at the
owns
corner,
And the yellow
next-
house
yeah.
is the church, so right behind.
Mary Flowers' old house.
Yeah, so that
Yeah.
family is very concerned about it because
Yeah.
they're kids and.
Yeah, okay.
But I think, yeah.
I got it.
Yes.
I got it.
Both neighborhoods are concerned, and then people are concerned about my house becoming commercial.
Becoming a what, I'm sorry?
Someone trying to get a variance at my house to make it commercial. So all the older folks in my neighborhood who've been there forever have seen people try to purchase our property to put in a professional office or whatever there. And
How long has that been a residence, your house?
it's always been, it was purchased by the Archdiocese in the 70s.
And it was part of the church for a while?
Yeah, until we purchased it.
Oh, so you bought it from the diocese?
Diocese, yeah.
The, is it, so I'm really kind of hearing three things, right? You've got this use issue, but that's really driving a traffic concern. And then you expressed concern about the look of the building. Is it a different proposal if the building looks like a residence in your mind?
I think so. I mean, we would still have the traffic concerns.
Yeah.
But I think that the way it looks, the gentleman from the Historical Society at the Planning Board sort of hit the nail on the head. As soon as you come around this is the first thing you see of Milton, and it would be, from the renderings I've seen, very large, in your face, white, big.
Yeah.
I mean, I think the color and different things that people are talking about would help, but I think it would be there.
Okay, thank you.
Okay.
I have another question for Ned.
Oh, yes, of course.
So Ned, this building was built in 1844, right? And so the Historic Commission was there at the hearing? And I know he said that he wanted the building to be turned perpendicular, but what about does the building have any historical significance? It's old. I mean, that's old, right?
It is, and for that reason, they voted to,
They invoked a demolition delay.
Correct.
And that's all they could do.
that's all they can do.
It doesn't really have any historic character, though, except for its age. And then you indicated that it had already been interiorly demolished.
Completely gutted inside.
Yeah.
Ceiling heights are very
It was
low.
built as a residence, though?
I think originally
Yeah.
they cited a person by the name of Harrington, I guess he used to sell
It was in the granite industry.
granite out of the Quincy quarries.
Oh, yeah, okay.
It was in the part of the granite industry, and it was connected to the granite industry. When the expressway was built, Adams Street was widened significantly. It pushed the front yard, pushed the retaining wall right up against the front of the porch. And I think from that point on, and given the commercial, I mean, when you look at aerials of this part of Milton going back to when the expressway opened in the 50s, it was a commercial stretch up and down both sides. There were 4 automobile dealerships in East Milton, including one on the corner of Squantum and Adams, and a gas station, and then the church and the convent. And this building became the doctor's office for McAuliffe in the 60s. Then you had Jubenville's building, which was offices and residential. And you've got the post office, and you've got the bank building across the street. There was a large Graceville residence that was converted into this new office building sometime in the 70s under a variance. The whole area, except for individual residences, is substantially commercial. Why it never got zoned that way, I don't know, but the Board of Appeals was called on to effectively rezone that stretch over time to recognize the existing zoning character of the area.
Is there been any attempts made to save the building, to move it?
No.
Nobody's approached it.
Could it be moved?
I don't think so.
Too big?
It's with the additions on the back, it's not,
The whole building's not 1844.
No.
no, there was an add, maybe a couple of add-ons on the back of that going towards the rear property line.
Fully done?
Yes, very much.
Yeah, okay.
In the exterior of the building, is vinyl siding, it's asphalt shingles, there's replacement windows, there's nothing historic.
I know, it's just, we don't see a lot of 1844s around, you know?
It was let go, whatever happened over the years, they let them use materials that aren't historic on the outside, and took that appearance away from it. And the inside is gutted to the studs, so it's,
That's red siding?
yeah,
Driscoll did that?
I don't know.
Probably not. Probably before. I mean, it's, because it's old,
I'll have to talk to
really
him.
old siding. You know, we don't have, Milton only has a demolition delay process.
Okay.
With respect to its historic. Can be determined to be historic, and that imposes the delay if they determine that it's preferred to be saved.
Okay, I'm all set. Thanks.
Mr. David, do you have any more questions?
No other questions right now?
Okay, fine. Is there anybody else who wants to be heard? Okay, there's no other such person present. So unless you have anything else, Mr. Corcoran, why don't we end the evidence portion of this proceeding, and the board can discuss this application in open session. Mr. Mullins, you want to be heard first?
I thought about an hour ago you were going to suspend the testimony for lack of definitive information, but that was an hour ago, and we're still here.
We are still here.
And I'm not sure that things have substantially changed. I understand the applicant is looking for an indication on where the board is, but I think we need a little bit more information in terms of what's being built, right? Don't we? Was that not the testimony?
Well, it depends upon what you believe is the function of the Board of Appeals. I think what the planning board is looking from us is they want to know whether it's extremely likely that we will grant the dimensional relief that the applicant needs in order to construct the project, because if we were not going to do so and indicate we're not going to do, then they don't want to waste their time going through a site plan approval process, and they don't want to put the applicant with all due respect, Mr. Hannigan, to spend thousands of dollars having Mr. Hannigan and/or others draw conceptual plans and do schematics and have nothing.
And you spoke to dimensional relief there? I'm not concerned about dimensional relief. I'm concerned about the use relief. I need to know whether...
I understand that.
But you just said dimensional relief, and I just wanted to clarify.
I did. The dimensional relief from the front sideline to where the building is, to the use requirement, and to the 10-foot variance you're requesting on the rear, but you've told us you don't think that's necessary.
We're withdrawing.
Well, to be frank, you can do anything you want. I wouldn't withdraw anything at the present time, because if you get before the planning board and they want you to stage that building back, or they want you to tweak the building in some way, and all of a sudden you need a 2-foot variance on the rear and you've withdrawn your application, then you're going to have to start again, and I don't think you want to do that. But I think that's what the planning board is looking for. They're looking for the sense of the board as to whether we are going to grant the relief requested. And I think the use variance is the most significant one, and then the dimensional variance at the front. I don't think we necessarily have to discuss the 10-foot variance at the rear, because at the present time, on this present plan, you don't need it. But we don't know that this is the definitive plan. So that's what the planning board is looking for. And I think in the past, this is exactly what we've done. We've indicated that here's how we're prepared to vote on these variance applications. And if we indicate we're going to go forward with the variance applications, then it goes back to the planning board. They do the site plan review. The applicant finishes up his plan, so you've got definitive plans. The planning board comes up with a whole series of relief, site plan relief, which presumably would include maybe modification of the sidings and the windows and whatever they want to do. This is their expertise in conjunction with the developer here, Mr. Conley. And they say, well, here's our site plan review. They send it to us. We write the variance decision, and we incorporate those conditions in the decision. And it gets filed, and away everyone goes. So as I say, I was impressed that the planning boards spent as much time and effort on a pre-site approval than they did. And I think they did that to try to give us the benefit of their wisdom as to whether they thought that this particular project was viable from a planning perspective, and whether it was in the best interests of the town of Milton. And they said, and Mr. Whiteside says in his letter, he does. He thinks this proposal is appropriate if the appropriate site plan conditions were attached. The matter went to the selectmen, and the selectmen heard a 30-minute presentation from Mr. Corcoran. They asked some questions. They talked about the facade of the building a little bit, but different people look at things differently. Two of the selectmen, they thought the building was wonderful. They weren't talking about setting it back or staging it back or twisting it or turning it. They thought it was just very well done. And they're elected officials of the town. So the selectmen were unanimous in their support of this particular application. And while they're not site plan reviewers either, they're in a sense the conscience of the town when it comes to appropriate uses that are not allowed in this zone, and as to whether those uses should be allowed for the benefit of the neighborhood and East Milton Square generally speaking. So that's where I think we are. If we have a sense of whether we want to grant the use variance, whether we want to grant the variance on the frontage, and we so indicate, and it goes back to the planning board to do their work and comes back to us. And so And if we don't have that consensus, it's got to be a unanimous vote. As you know, Mr. Conley, it's a unanimous vote of the board on all of these things. Then they're not going to conduct any further hearings. So that's where we are. And I think I don't think we necessarily have to vote the variances tonight, but we could do that if we wanted to. But if we're going to give the planning board a sense that the board is in favor of this use variance, then we should do it and say it in a fairly definitive way, because it's not going to come back to us after, say, 2 sessions with the planning board and to have the Board of Appeals say, well, you know, we don't like this use variance. I guess we're not going to do it. And Mr. Conley spent a fortune on multiple plans, and the planning board spent hours and hours on this and writing conditions. I mean, that's disingenuous. It's not fair to the planning process. It's not fair to Mr. Conley. So that's the procedural process, as I see it. They're looking for the sense of the board as to whether this application has merit, subject to it being tweaked by the planning board in the ways that we've discussed, and not second-guessed by the Board of Appeals, because we think the building should be set back or tweaked. I mean, that's not fair at all. It's the job of the planning board to either get the applicant to set it back, to twist it, to tweak it, to do colors, whatever they want to do. They're the experts. Mr. Gaius is a well-recognized expert, and that's their job. That's not our job. We're not hired to do that. We weren't appointed to do that, in my view. So do you want to discuss the sense of the variance aspect of this and see whether it makes sense to send it back to the board or not? I mean, if you want Mr. David to talk about it, he will. If you want me to give you my views, I'm delighted to do it.
Whatever. I'll talk. You want me to say something?
Well,
Here's what I think.
It may be helpful if we heard from you.
I think there are a couple of issues. I think we heard some pretty important testimony on traffic here, and traffic's related to use, and use is a matter of our jurisdiction. It doesn't seem to me unreasonable to ask for some more evidence on this, and it doesn't seem to me to control that wrong way move down Adams.
Well, you're right, but you're not saying we're going to enact measures to try to prevent people from breaking the law.
No, what I'd like to see is something from somebody like Bill Clark or the Traffic Commission as to whether or not that move across 4 lanes of traffic on Adams Street with everything else that's going on in the square is going to be exacerbated or not, in their opinion. I think something like that, because what I'm concerned about, I'm less concerned about the use and more concerned about the traffic. And I understand the testimony has been these are related activities, but I think that's the sense of what's really going on here. And I didn't hear much about traffic, and I just don't want to discount it, because what I heard is somebody's going to get hurt. And when you hear somebody's going to get hurt, I'd like to just hear some more about it. And I had another point that I was going to make, but and then the second point is, it seems to me something's going to happen here, because it's too important a parcel of land to keep it the way it is. And I would not support keeping it the way it is, because I think that's a bad and unsafe condition. So I think an important message to the planning board is that their time is not wasted, because something's going to happen. And I think it's good that something happens there. What happens there, I don't know, but I don't feel like we have enough information to actually take the vote, John. And my main concern is public safety in the public way.
All right. Mr. Deva.
I agree with the concern about traffic. I mean, I heard a lot about that loud and clear, and I tend to think that, if the last time this building was really used by anybody, or anybody had to make that turn regularly, was 7 years ago, I think it's fair to say that there's a lot more traffic now through East Milton Square at various times than there was 7 years ago. I mean, there's a lot more traffic in all parts of Milton than there was 7 years ago. So I guess, that is a concern. I'm not the best way, I don't know what the best way is to deal with it. Jeff had a suggestion about trying to get some more evidence from Bill Clark.
I just want somebody who knows, has a better sense of what's going on in the square.
And I think it's also fair to say that, if you do have people coming to offices, whether it be doctors, I mean, probably lawyers' uses would be less intense than doctors. Doctors tend to have appointments like every half an hour or so.
Make more money than lawyers, too.
Well, they double book appointments and surgery now.
Some of them do.
The only other concern I would have about use, and I'd be interested to hear what you think about it, was that the thought that at least in one of the buildings, I think somebody said that a variance application had been made to make that, downstairs offices and upstairs residences as well, and there's a concern that, I guess, although I'm not sure it was set in these terms, that, the more of these you have, the more precedents there are or something, and that people can latch on to try to do additional, go for additional variances of the same thing and the same type and hold this up and say, well, they got a variance, you know. So I guess I'd just be interested to hear thoughts on that. Otherwise, you know, I think, you know, as Jeff said, something's got to be done with the property. The fact that it's also done in the, this is a similar use on the Jubenville property, I think it does make some sense, and the planning board thinks it makes some sense, too. So,
Well,
I should also say, I mean, I think the fact that the building is not being converted from residential to commercial is important, too, even though that was it sounds like it was a oh, no, Ned said it had special permit or some type of relief from the board previously. Right. I think that makes it a little bit different than the conversion of a residence.
I agree.
You know?
I agree. No, I mean, the fact that historically it was used for those purposes before it, No, I agree with that. Sorry.
No, sorry. I think I view this differently from my colleagues. I look upon this on the question of the use variance, forgetting dimensions, architecture, and all of that. It is what at the end of the day, what's in the best interest of the town of Milton? Okay. If I had real concerns about anything that I've seen, and I've seen this building, my concern would really be that this building doesn't get set on fire or doesn't go on fire and burn the church down and burn Mr. Jubenville's building down and burn anything to the rear of that property. The building that I saw was a haunted house. It's a disaster. It's a fire waiting to happen. It's a structure that is, I don't know whether it's been condemned by the building department. We haven't had any evidence of that. But to me, if we had a less genteel group of high school students and grammar school students, they'd be in that building tearing to bits. You'd have homeless people in there in less affluent communities. So my concern is that the building should be knocked down and demolished. But you have to understand that Mr. Connolly is a developer. He's not going to knock down the building and incur a fortune unless he knows what he can build there. So that's concern number one. I think on the use variance, I don't think that's a close issue at all. We're appointed officials. We're not elected. We couldn't be elected to anything, in my view. So you have the planning board who are experts, and they say that this site is being appropriately developed and it's the best interest of the town of Milton, with site plan approval and specific mitigation measures. Number two, we have the selectmen who are up for election all the time. They fully supported the plans as they presently exist. They think this building is in the best interests of the town of Milton, that this use is not overly intense. So to me, the use variance, looking at the way the property presently exists, I think a public hazard, and that's not your fault, Mr. Connolly, it's just the way things get drawn out here. That's an easy one. The dimensional variance on the front, under these specific facts, I think that's easy too, because you're going to have a 6-foot variance no matter what you do. So if you have to drop it back a little bit, you're not impinging more on the variance, you're impinging less. So that if you could set the building back in some way, which may not be possible, you're not going to exacerbate the conditions, you're going to improve it and make less impingement on the frontage. The 10-foot variance to the rear, I don't think you need. So that I admit traffic is tough on Adams Street. The the way this project is being planned, I don't know what else the applicant can do but leave the driveway exactly where it is. It's been widened. It's at I'm going to say the western portion of the property, the far western portion. So if you're going to have access to this property,
It's eastern.
east. Well, I have this saying
It was
north.
actually moved about 15 feet closer. to-
Okay, it east. I'm sorry, it is east. Thank you. East. This is east. So the driveway is the best position it can ever be in. It's better than the position that it was in when the doctor's offices were there. So, my view of this is that, and I've made this turn many times, I can say that it's not an easy turn, but it depends upon the time of the day. If you get commuter traffic going there, it may be difficult. But on the other hand, I think that this is the least intense use. If you put 4 residences there, or you put 6 residences there, I think you're going to have more traffic problems than less. We don't have any traffic engineering reports. Mr. Corcoran told us that. I've dealt with traffic engineers. Sometimes their views are mysterious at best, and they charge you a lot of money. I don't, acknowledging there are traffic issues on Adams Street, there's traffic issues all over East Milton Square, I don't really draw a clear relationship between saying we've got 2 apartments and 2 offices of 1,000 square feet, and certainly it's not going to generate a lot of people working there, that somehow there's going to be some enormous traffic issue, some enormous safety issue. I don't see it. We certainly don't have any information. Mr. Corcoran said he's not going to hire a traffic engineer. Is it an issue? Yes. Is it legit? I've never heard of this area having a lot of accidents, but the neighbors say they do have accidents. The police department's got record of all of these, of every accident that gets reported to them. And I guess the question is, are we going to require the applicant to get involved in that type of detail, delay this hearing some more, and turn this into a traffic issue case, which I don't think it is. I don't think there's a lot of evidence. This is not Randolph Avenue, I can assure you there. I've taken that turn many times, but I know this. It's difficult to see some of the cars coming up Adams Street, but you go very slow. You don't go shooting out into that intersection. You go very slow and you work your way across it. So I honestly don't feel the need to get involved in traffic statistics and that, but if my colleagues want to do it, we can certainly do it. I think at the end of the day, we're going to be in the same position we're in now. So that's my view. If I had my druthers, I would think the application has been sufficiently presented to earn my vote for the use variance, the frontage variance, and to send this back to the planning board. But if you want to continue this for another short period of time and let Bill Clark get involved in the traffic issue, or let Mr. Corcoran introduce whatever evidence you want to, then we can do it. I don't think it's worth the waste of time. I think this whole project's been delayed too long, particularly with a building that I seriously question whether anybody would think that it could have been restored or saved. And particularly with Mr. Conley's testimony here that its only distinction of being historic is its age, but you're going to find tar shingles on it and other things that certainly have no historic significance. So that's my view. If the sense of the board is they want to hear more evidence on traffic, whether it's from neighbors, from the police department, statistics from the police department, from a traffic engineer, that's up to the applicant what he wants to do. I don't see it, but that's, I just have one vote out of 3. My only suggestion is that if we're going to have another hearing discussing traffic, we should limit the hearing to the traffic issues. The hearing should be held in a very short period of time and not weeks and months from now, and vote it up or down. That's the way I see it.
I thought we were working to give the planning board a sense of where we were headed, and therefore didn't need to take the vote tonight.
We don't have to take the vote
What's the
tonight.
problem with asking the planning board to have their hearing? See what's being built.
I wouldn't do that, and I'll tell you why, Jeffrey. Because the planning board's going to say, well, what if some of the neighbors come up with a traffic engineer who's going to say that this is a nightmare and it's unsafe? And that hearing is going to go on forever, and we're going to fight forever on it. Why are they going to spend they spent an hour on this application already. So why are they going to spend 4 or 5 hours on the application when traffic is, I don't believe, well, entrance and egress from Adams Street, I guess is something within the site plan review. Maybe they want to weigh in on the traffic issues to a greater extent than we can. Maybe that's the alternative. If we give the planning board a sense that we're inclined to grant the use and the dimensional variances here, that there's a concern with access and ingress, that maybe through site plan review they can mitigate, and that's fine too. But I don't think we should send it back to them with with an indication that we still may think the traffic is sufficiently difficult so as not to award the variance and the relief granted. I think that's unfair and disingenuous for us to do that. That's my view. So, do you want to have a hearing in a week or 10 days or something like that on traffic issues?
No, I wanted Bill Clark's view on problems with traffic. That's what I wanted. I didn't want a hearing on traffic.
I would
Concerned about
suggest
traffic.
Bill Clark participated.
Do you think traffic, let's talk about it this way. Do you think the traffic issue is directly relevant to the concern of the Board of Appeals?
Yes.
Or is it something that is more appropriate to be discussed and handled by the planning board?
I think the planning board dealt with it in site plan review, that'd be fine, but I don't see anyone dealing with it.
What they did deal with was the location of the driveway.
Okay.
And went from one side to the other as the safest place.
Anybody said that it's safe? I didn't hear that. I didn't hear anything on traffic.
Jeff, something's going here.
I agree.
The safest place to put the access and egress is where it's located, closest to the Jubenville side of the lot. Where else do you put it? You don't. Is anything
It's
else?
not just about the driveway, Ned, right? It's about whether or not there can be some measure taken within the right-of-way to avoid people taking that illegal left, in this case. I don't
Well,
know.
you put up a sign, or
illegal
you have a
left?
policeman there.
illegal left.
That's not the job of the applicant to enforce the police laws.
This is a huge
Swear.
issue. Traffic is a huge issue over there. and
I agree.
You cannot pile.
I heard very
on
little-
and you can't pile on a very small.
I'm asking for people. I'm asking for some professional opinion as to whether or not the traffic is going to be a problem. We heard, that was the issue we heard from the neighbors, traffic.
You know what you're going to learn? You're going to learn.
know what I'm gonna learn.
Well, I'll tell you what you're going to learn, because it's pretty obvious. If you drive there, as I drive there, you're going going to learn that from 7 o'clock in the morning to 8:30 in the morning, it's an issue. Everyone has to face it. You move slow, it's an issue. That from 10 o'clock in the morning to 2:30 in the afternoon, it's not an issue, that you can make that reasonable turn into the driveway. And that on Sunday mornings, it's easy to do, and on Friday nights, it's difficult to do. You don't need all the statistics to, that's obvious for anyone who drives in this area. If you want to hear from Bill Clark, maybe he'll write to us.
I don't know, Ned said he had something to say. What did he say?
He participated in the planning board meeting last week. There was no issue of traffic concern, no concern about traffic. I don't know what else to do and come back to you. I can tell you that the client does not have an appetite for another night before you and 2 more nights before the planning board and then back to here.
Well, you don't want to say that, because you're going to end up going in the wrong direction. You're trying to make progress here. So it seems to me if 2 members of the board think that we should have additional evidence from Bill Clark, we're not talking traffic engineers, then what's the problem?
I'll ask the client if he's willing to engage another night with Bill Clark to talk about whether or not there's an issue of traffic associated with this development. I mean, I'm not going to bring in a traffic engineer to evaluate the traffic that's going on in East Milton Square associated with this. We'll go off in another direction if that's the desire of the board.
It's not the desire of the board. It may be your desire.
No, it's not.
You sound like you're trying to encourage the board to enter a decision here not to grant the relief.
I'm asking the board.
And it's within our discretion. You understand.
I'm asking you.
You can prove every iota of element of variance, and we can still say no, because we don't want to do that here. But I think you're aggressively suggesting that unless you get what you want here and now, that you really don't care what the board does.
Mr. Chairman?
Yes.
My only concern with Mr. Mullen's position is I don't know what Bill Clark is going to add to this that hasn't already been talked about. Bill has seen this plan for a long time now, and it was at the encouragement of the board that he's a part of to move the driveway. And I think there's a consensus that is the best location for that. And as far as traffic, and I understand the neighbor's position that, a professional office use, the clients that come there, they might be unfamiliar and trying to ease on and try to get over.
You just go around the block.
You go around, and once an office is there for a certain amount of months, the people know to come up Brook Road or from Adams, that come Squantum Adams and take the right in anyway. I don't think there's an issue there any more than there is now for anybody driving that. I drive that every day. I live in East Milton myself. It is what it is. A study or Bill Clark or anybody else isn't going to change what that site is. I know that from my perspective, I have a lot that I can put 2 houses on. This is the best use for us. I don't want to do the 2 houses. I don't think it's appropriate, which means a common driveway or 2 driveways. The driveway has to access the lot. I don't have a choice. I got to get on the lot. So I just don't see what that's going to add for us.
That's fine. That's your view. I appreciate that. Thank you.
Thank you.
I just don't want to be bullied, okay?
Okay.
I'm not bullying.
I'm not bullying.
And
I don't know about that.
That's certainly not my position.
I apologize.
You are the-
It's
you are the
not,
applicant.
but
I understand that.
I'm not sure what else you could do.
Well, I think what Mr. Mullen is suggesting is that he would like to hear, not from a traffic engineer, but from Mr. Clark, as to whether the suggested use here will cause serious public safety issues. And he's the planning director of the town. He's not here tonight, so nobody asked him to be here tonight. So I can't say that there's something nefarious about that. And if you don't want to come to another hearing to listen to Mr. Clark, you don't have to. But if that's the case, we would like to know here and now, and we will vote on the application, and the vote is going to be negative. And I don't know why, with an application that the selectmen and the planning board says has merit, but it needs tweaking, you want to blow up the application. It doesn't make any sense to me at all.
My position is, if if this board votes to have Mr. Clark in here to discuss traffic about this application, that's fine.
And I think it can be done in a discrete, short period of time. Bill Clark's familiar with all of this stuff. So that's my view. If Mr. Daber and Mr. Mullen think that they need to hear more on the traffic, I think they're entitled to do it. Just because I don't think you need it, I'm not the Board of Appeals. I'm just a member of the Board of Appeals. So my suggestion is everyone take a deep breath, check your calendars, and we'll pick a date.
Tomorrow night.
Well, my guess would be, you're before the planning board. Did you say, Mr. Corcoran, did you say 26th?
Yes.
Okay. Do you have your schedule, Jeff, before the 26th, and Ted? And if we can...
Yeah.
Yeah, well, what we should do is try to schedule something that's perhaps, this is the 12th, maybe sometime next week, so that there'll be, you're just losing a week.
Sure.
You're not losing a week. I don't understand that, John. I just don't accept that. There's much more process. It's got to get the planning board view. It's not losing a week. There's no building going to be starting tomorrow.
No, but we're supposed to give the planning board an indication.
They can read the minutes. They can listen to this hearing. They understand the sense of the board.
That's not their function.
I get that, but I don't want to be forced into a vote that I'm not prepared to make. And
Okay, then what do you want?
that's all I'm saying.
What do you want?
No, what I'm
assume-
objecting to is that the inference that the board is causing a delay here. Well, I had a reasonable question. I didn't get an answer.
Reasonable question, and then
That's it. This is the first time I've heard this matter.
you're entitled to the time to hear the evidence that you think is relevant. I am suggesting that for the benefit of all parties, it would be helpful if Mr. Corcoran and Mr. Conley are available in about a week's time, when sometime we get Bill Clark in here, and then you've still got a week before you get to the planning board hearing. And that's a sensible way to do this. Mr. Davis.
Yeah, I just have to say, if we could have it, and I'm, like by Tuesday night, that would be helpful to me, because I'm having surgery Wednesday.
So what kind of an excuse is that?
And I'm supposed to be staying at home Wednesday, Thursday, Friday, so,
Okay.
next week, so.
Well, we wish you the best. How should... Tuesday, you could do it here. How's your schedule, Mr. Corcoran? Mr. Mullen, what do you have to say? I think I'm generally available.
I can figure out how to make it.
I can't do Tuesday. I can do Monday.
We're talking the 16th? Is that right?
Yes.
Good grief. Where's the time going?
Monday's better for me than Tuesday.
Monday's the 16th. I can do the 16th.
I can do Monday.
What time would you like to start it at?
What's comfortable? 7, 7:30?
Fine, 7:30, whatever's comfortable for the board.
Mr. Mullen, you?
7:30. Have to be 7:30.
Okay. So let's do this. And I guess the only question will be Mr. Clark's availability. And that's
Okay, no, go ahead. Finish what you're saying.
I was going to say, you're in surgery on Wednesday?
Yeah.
Okay, so it really almost, it almost has to be the 16th. Okay, so with the agreement of everybody, let's continue this hearing till the 16th of October, 7:30. Will we be here, Mary?
Yes.
Okay, and who's going to contact Mr. Clark? Do you mind contacting him?
Contact him first thing in the morning.
Yeah, and see if that's available. Now, if for whatever reason, Mr. Corcoran, that's not good for Mr. Clark, say he has something for the kid's graduation or some wedding anniversary or something, I'm amenable. What's your schedule in the afternoon on the 16th, Mr. Mullen? Can you do that?
Here in the afternoon?
Yeah, I mean, if we had to go 5 o'clock, 4:30 or something to accommodate Mr. Clark if he couldn't make it in the evening.
This is on Monday?
Monday. I'm available if need be. We're going to schedule for 7:30, but if we have to, we'd have to notice it very quickly here, unfortunately, but we'll know tomorrow. Mary, you could get an ad or get a notice and...
I can do it tonight.
Okay, well, you put it on for the 17th tonight, but if that's, strike it, the 16th, but if that's not, the time isn't convenient for Bill, you know, we'd want to try to accommodate.
Would it be helpful if you said you were continuing it until 5 o'clock on Monday and to 7 o'clock on Monday, so that this hearing is continued and those who are here know it's, and then you're
No,
calling off the 5 o'clock?
I'd prefer to pick 7:30. In all probability, if Mr. Clark is around, he can do it. He wants to accommodate it. He's just a wonderful guy. He'll try to accommodate him.
I can text him right now and see whether that's something.
That'd be great. Jeffrey, do you have any time earlier if you had to do it at 6 or 5:30, or is that a killer for you?
I mean, I could do it, I guess, if I move things around, but it's just hard for me to get here any time earlier than 7:30. I just barely made it tonight.
Okay, so, okay, well, we're going to do our best to insist on 7:30, and I think what we're looking from Mr. Clark, we're not looking for him to do an engineering traffic study of this area. We want him to use his best knowledge and information and his expertise as the planner for the town. He's familiar with this. I guess somehow if maybe you'd want to look into, it's entirely up to you, Mr. Corcoran, you're the lawyer for the applicant here, whether there's any statistical evidence to show whether there is a proliferation of accidents here and how serious they are. I mean, the police keep that type of statistical data. It may be helpful. What you're not going to find is how the incidence of accidents increases or decreases depending on this particular use, 4 apartments or 2, but just in a general sense. And I think I watched the hearing with the selectmen, and I think Mr. Clark was present for the planning board session as well. So I think he didn't weigh in to any serious extent that I saw on the traffic issue. And I don't think the planning board gave it a lot of weight, but let's find out. You're not delayed very much, and we can get a sense of where we're going.
Sure.
Does that make sense?
Yes.
Because the ultimate question here is going to be what's in the best interest of the town, and I don't know that anybody is going to start suggesting, well, you should tear down the building and turn it into a park or a farm or something. I mean, that's crazy. So we're going to adjourn this hearing until the 16th at 7:30, and Ned, you can send us an email or something if you have Mr. Clark's participation. Is that fine with you, Jeffrey? Okay, and Ted?
16, yeah.
Yeah, and this will be a short hearing. I wouldn't expect it to be more than half an hour. Okay?
Thank you for your time.
Great, thank you.
Thank you.
We're adjourned.